Hello, Wendy.
Hey Trish, how are you?
Good. You're all good?
Yep, not too bad. Can you hear me all right?
Yep, you're good. Yep.
Oh, good. Good.
Okay.
Right, I'll unmute myself again now.
Same.
Can you hear us, Wendy? No, and Trish?
Yes, Josh, you're
Great.
perfect.
Thank you.
Yep. Amateur. That'll be good. You and I can make a good team. Right. Welcome and good morning, everybody. Do we have everyone connected? Okay. This is a hearing to determine an application for a resource consent by the University of Otago to develop an academic retreat and conference facility at 831 and 833 Woolshed Road, Jacks Point. The application reference number is RM200570. My name is Rachel Dimery and I am chairing this session today. I am a planning consultant from Auckland. My fellow commissioner is Jane Sinclair, a planning consultant and independent commissioner from Queenstown. We have been appointed by Queenstown Lakes District Council with delegated authority to determine the application. We're assisted today by a number of officers and consultants to Council, Trish Anderson, our Planning Support Officer, Wendy Baker, the Reporting Planner, Richard Denny, Landscape Architect, and Jamie Exeter, an Acoustic Engineer. We visited the site yesterday afternoon and walked over the site along the lakefront and drove and walked around the immediate neighbourhood to view the site from different vantage points. So we may do another site visit following this hearing, but we're familiar with the site and all of the application material and evidence that has been provided. Before I get underway, I'll just cover some housekeeping matters. This is an online meeting, and if everyone would please silence their phones and ensure that there's no interruptions when you're speaking and not on mute. And if you're not presenting, please mute yourself so that we do not get disturbance and background noise. The hearing's set down for one day today, and we'll break for morning tea at around 10:30 and lunch 12:30, afternoon at tea at 3 p.m. if required. However, we'll have some flexibility depending on how matters proceed and won't wish to interrupt any of our presenters as if they're in the middle of critical points. We'll follow the usual order with the applicant presenting first, followed by the submitters, and then the reporting officers will have an opportunity to respond to what they've heard and provide clarification on any questions from the Commission. There's no cross-examination as it is a council hearing. Depending where we get to, we may provide the opportunity to Mr. Leakey to provide his reply in writing, depending on his preference. We've reviewed the application, as I said, and we will take all the evidence as read, and I thank the applicant's witnesses for their written summaries, and also the submitters, the Jardines, for their written summary. Just some final matters that we wish to confirm that neither Commissioner Sinclair nor myself have any conflicts to declare, actual or perceived, and that in terms of the information we have a plan bundle provided in hard copy, nice big A3, and a written statement from the Jardine, and as I said, summaries from the applicant's witnesses. We received the legal submissions this morning and have not had an opportunity to pre-read those. So I will now hand over to Mr. Leckie to begin, and we're in your hands, Mr. Leckie.
Thank you, Commissioner Dimery and Sinclair. I've got quite a few people with me here. If you're minded, I won't go around the room at this stage, but I'll just introduce the team as we work through the course of the morning. And just some housekeeping as well. The submitters that you've already mentioned, the Jardines will join us from here to do their presentation a bit later today as well. Thank you for just confirming that you've received the bundle. We appreciate there's been a lot of provision of plans, and we thought it would be helpful to have them all in one place for today. So the team and I will refer to that as we go. The way we're proposing to do it is the page numbers at the bottom run through the whole bundle. So we'll use that as a reference point, as will I, as I work through the submissions. I should also introduce Catherine Hockley to my right, who's assisting me today on this file. Our submissions are quite lengthy in that we've been conscious to provide some background to the proposal and also to the quite complex planning framework out at Homestead Bay. So I won't read all parts of them in their entirety as they're intended to provide helpful context, hopefully, for the commissioners. Starting at page 1, of course, these opening submissions are on behalf of the University of Otago, who are seeking to establish and operate the Hakitakura academic retreat and conference facility, which I refer to as the proposal. The site was gifted to the university in 2016 by the Jardines, Dick and Gillian Jardine, with a vision for Hakitakura that it will provide for the academic meeting of minds from New Zealand and around the world. The name Hakitakura was gifted by Ngāi Tahu to the university and to this site. And the gifting of the name in my submission is significant, and it represents the evolution of the relationship between the local mana whenua and the university, and the significance of the university's vision for this site. And the university approved its internal process in 2019, which has really kicked off the consenting process where we're at now. My submissions will outline the framework for your decision-making for this proposal when considering the granting of consents. Paragraph 7, in my submission, the proposal has significant positive effects for the community, and it's a key part of this proposal. There has not been a concept like this before in Queenstown. When considered against the existing and anticipated environment for the site and the wider area, the adverse effects of the proposal will be no more than minor, and the proposal in our submission and supported by evidence for the university is consistent with the objectives and policies of both the relevant planning documents for Queenstown, the operative and the proposed plan. The vast majority of issues have been agreed between the university witnesses and the council, and I don't propose to sort of dwell on those. In terms of the key outstanding issues, they're really, from our perspective, landscape and servicing, in particular wastewater. At 8A, in relation to landscape, the landscape and visual effects of the proposal are appropriate, and it's important to consider those in the context of the existing and also the anticipated environment. And I'll spend quite a lot of time on that anticipated environment this morning through my submissions. The university has volunteered a comprehensive landscape protection and planting plan. It's included in the bundle, and Mr. Esplanade will walk us through it as well today. There's been some amendments to the proposal in response to Ms. Baker's report. In a visual sense, that includes an amendment to the cladding for the new buildings that we will cover off today as well. Over the page 2, in relation to wastewater, the effects of wastewater will be appropriately addressed by the proposed staging, and that's ensured by condition 9. The conditions are in the bundle and also attached to Ms. Taylor's evidence, and that will ensure that the subsequent stages of the proposal cannot be constructed until there is a reticulated wastewater system in place in this area. And again, I'll spend some time on that this morning. Overall, we submit that the proposal meets the gateway tests and is appropriate for grant of consent also under 104. I've expanded on the proposal slightly. Ms. Murray in her evidence will give some more detail on this. There are some caps proposed to ensure effects are appropriately managed. A key one is at paragraph 12, around a maximum of 31 private or large events. So these are events with 100 guests or more, including staff. And the remainder of the time, the site will be used for smaller university gatherings and events. And it's condition 34 where these controls are ensured. Due to wastewater constraints, which the whole room will probably be tired of hearing about by the end of this hearing, the university proposes to carry out the proposal in stages. So the initial stage will be constructed before there is reticulated wastewater to the Homestead Bay area, and it relies on an interim wastewater solution that Mr. Lloyd speaks to. Essentially, it's a wastewater holding solution. This stage includes the redevelopment of the existing wool shed. So that is the historic Jardine house, which was converted from a wool shed, and the university proposes to adapt for the initial stage. So it's an existing building, and it will have a cap of use of up to 65 people, including staff. Demolition of the sharers' quarters, which, if you're looking at the existing wool shed from the lake, is to your left. And also the construction of a new staff residence, so an on-site caretaker, a relatively modest dwelling, and some ancillary structures such as solar and garaging as part of that initial stage. Well, following confirmation from council that the reticulated wastewater in the area is under construction, the subsequent stages of the proposal will be triggered to be constructed, and that's a key change from the proposal assessed by Ms. Baker, which allowed construction of the subsequent stages prior to the wastewater scheme. Its trigger was occupation. So that's an amendment made by the university to address the concerns of Ms. Baker about potentially redundant subsequent stages that can't be occupied. Those stages can now no longer be constructed until the wastewater scheme is under construction. What those are is the lecture theatre, which could potentially be constructed in two stages, and Mr. Ritchie can speak to how that would work. And that's a facility for up to 125 people, and also a visitor accommodation unit wing, which is part of the subsequent stages. If you're looking at the existing Homestead woolshed building, that's to the right from the lake. And Mr. Ritchie has a nice site plan at page 19 of the bundle that has all these buildings shown on it. And the subsequent stages also include associated landscaping that relates to the mitigation of effects of those subsequent stages. For the benefit of neighbouring properties and mitigation of effects, there are further limits proposed on the operational aspects of the proposal. I've talked about the capacity limitation, 65 for the initial stage and 125 for the subsequent stages. An operating hours cap is proposed, 8 AM to midnight, except for the visitor accommodation, obviously, to avoid people not being able to go to sleep. There's a prevention, a black and white prevention through conditions of coaches not using the site. We've talked about the 31 limit on large events, those being 100 or more guests. There are lighting controls proposed. These are at condition 7 and ensure compliance with the Southern Light strategy, which is becoming more prevalent in the Queenstown region. And then the noise mitigation, which I've largely addressed. The additional point there is a control on windows and doors being closed within the woolshed and lecture theatre when there is amplified musical speeches, with the exception of the lakeside windows and doors. And Mr. Trevathan has assessed these effects and can speak to these mitigation proposals. Moving to the activity status, land use consent is obviously sought for the proposal and required under the ODP, PDP, and also the NES for contamination. Ms. Taylor and Ms. Baker are agreed that the activity is a non-complying activity, and that has the implications I've spoken of regarding the gateway tests and also 104. The particular rule triggers have been assessed by Ms. Taylor, and Ms. Taylor can speak to that. Just one point that's now agreed between Ms. Baker and Ms. Taylor is Rule 41.5.4.10, that it's not applicable. And I don't understand that's a point of contention. There are other consents required which are outside the delegation of the commissioners today. These are ORC consents, and those applications have been made, and I understand ORC staff have been on site as well. In addition, there's likely, and sorry, I'm ad-libbing now, after paragraph 19, there's likely to be the need for an archaeological authority as well, which will follow, but is not the subject of this hearing. And that's due to the age of activities on the site, and will be focused on outside effects, earthworks, etc. So some more background on the site. It's well established that the environment for this application needs to be considered. It is the legal receiving environment, and this includes the site, including any permitted and consented activities already undertaken, which in my submission is important here in terms of the existing farm domestication on this site. It also includes the site as it could exist in the future, including through future permitted current permitted activities that could be developed in the future, and also any unimplemented resource consents likely to be implemented. And that's not a particularly relevant one in this instance. The site is 4 hectares. It's Jack's Point zone. Previously under the ODP, the Jack's Point zone was a resort zone. There's several resort zones in Queenstown, including Millbrook. Through the PDP, it's become the Jack's Point zone, and it's no longer a resort zone. It's now, well, some call them a special zone, but it's an urban zone that's not a resort. The proposal is located in the lower eastern portion of the site. The western portion, which rises up the hill, we colloquially call that Jardine Hill, is an ONL, and no developments proposed within the ONL. 24, an important point in my submission that will flow through the evidence today is that this proposal does not seek consent for new residential development on vacant land. And importantly, it does not involve the subdivision of land. So it's very different to almost all other activities within the Jack's Point zone, and also the likely activities we're going to see in the future in the Homestead Bay part of the Jack's Point zone. And that's what, in a planning sense in my submission, sets this proposal apart from the vast majority of other applications in the area. I won't repeat 25. At 26, the effects of the proposal are required to be assessed considering this existing environment. And in light of Hawthorn, it is the effects of the difference between the site currently and what is proposed that is to be assessed. So looking beyond the site now to the broader receiving environment surrounding the site, there's Crown-owned land in a lakeside reserve to the south and southwest. So that's, if you're on the lake looking at the proposal, that's to the right-hand side, and it's open space zoned. There are 2 existing residential developments to the north of the site. One of these is the Jardines dwelling where they live, and another is the what's referred to as the gatehouse. It's also owned by the Jardines, and a caretaker for the Jardines lives in that house. The Remarkables mountain range obviously frames the site and the broader Remarkable station land. And between the site and the Remarkables is the proposed Homestead Bay village. And if it assists as the morning goes on, we can walk through the planning maps. That's a village zoned through both the ODP and the PDP through structure plans. And then the more obvious visual form already in place is the existing Jack's Point development, which is further to the north and northwest, which the commissioners likely drove through yesterday to get to the site. So that sets the scene for what I submit as the legal existing environment. Moving to the anticipated environment at 28. In my submission, in addition to that more strictly defined legal environment, the commissioners will need to turn their minds to what is realistically anticipated in the future by the PDP and council policies. I've included some case law here where analysis of this broader anticipated environment forms a core part of the court's consideration under 104. And just again, ad-libbing here, in my submission, this is going to be particularly relevant to your consideration of the landscape evidence, and in relation to the landscape evidence, the visual effects of the proposal in the landscape context that they need to be considered in. So there's a recent local High Court case of Frost, which was a judicial review of a house in Wanaka, a notification judicial review, and the court endorsed the consideration of the anticipated environment supported by the objectives and policies of the plan when determining effects. And I won't read the extract, but I've quoted the key bit there at the bottom. It would be entirely artificial to assess effects without considering what exists and what is anticipated in the zone. And the High Court there said the council was correct in how they'd done that in that case. That's consistent with an earlier case of the earlier Tasty Products case, which also related to notification and put weight on the objectives and policies of a plan when assessing effects. And an older case, but a local one, so relevant also, is the Queenstown Central case, which involved the proposed Pack and Save and Mitre 10 developments at Frankton Flat. And there the High Court held that a real-world approach was required to assessing the future environment against which effects should be considered. The court held that the objectives and policies of a proposed plan, which is relevant here, served as a guide to the future environment against which the effects of a proposal were to be assessed. So my submission, drawing on that case law, the effects of this proposal need to be assessed against the environment anticipated by the objectives and policies of the PDP. And at 29, I just add there, sorry, that should also say the ODP, and that the village within Homestead Bay is zoned through the ODP. Also relevant to the PDP is the zoning on this site, which I'll give some more detail to shortly, which is a large lot residential type zoning proposed over this land. So as I've identified earlier, the broader Jacks Point and Homestead Bay areas are all within the urban growth boundary, and this includes the site. In my submission, this indicates that these areas have been identified by council as an area where urban growth can and should occur. And the policy of the Jacks Point zone anticipates substantial further development in the Homestead Bay area to the south of the site. And this includes a marina, substantial visitor accommodation, which in the form of several quite large hotels, and residential development. And some of that's already occurring. If you're looking at from the proposal looking out to the lake, you can see there's an existing subdivision and one house under construction within that Homestead Bay area. And further, the PDP anticipates further built development on the site itself, which I've just briefly touched on already, by virtue of the rule framework for 10 dwellings within what's called the OSR North area. And that's within the decisions version of the PDP, the proposed structure plan. So moving now a step beyond the PDP as to what this environment will look like in the future. The council's intent for future urban development within this area has also been further recognised in the Spatial Plan that was released last year. And the Spatial Plan identifies the Southern Corridor as the future growth area for the Queenstown Lakes District. Specific to Homestead Bay, the Spatial Plan identifies the area as a future urban area with a proposed local centre. And I've included the Spatial Plan in the bundle, and it's potentially a good time to just take the commissioners to that, if I may, which is page 89 of the bundle, just to provide some context. And on the left-hand side of page 89 is the large orange dot, which is the proposed new centre at Homestead Bay. The white colouring, confusingly in my view, is the urban land, not to be confused with white zoning in the unitary plan, which is future urban land. And then the yellow is future urban development, which is the land commonly known as Lot 8. It's also owned by the Jardines between the zoned Homestead Bayland and the State Highway. So in our submission, the spatial plan is a relevant council policy to be considered by the council when determining the extent of the anticipated environment. And I appreciate, and we'll get to the weight that can be put on this. In my submission, it's less weight than the PDP, and that this isn't a district plan style document, but the spatial plan is the guiding document for growth in Queenstown, and is a very relevant consideration. Just to put some context around potential development enabled by the spatial plan, for the land shown as future urban in yellow on page 89 of the bundle, that's estimated to equate to between 2,000 and 3,000 residential units. So it's a significant area of future development for Queenstown.
Sorry, Mr. Leakey, was that the yellow part or the white part?
That's the yellow part, which is just the yet to be rezoned, and that's subject to appeal through the proposed district plan. So the appeal by Remarkable Station, which is the Jardines, seeks that land be rezoned as Jack's Point, and Remarkable Station are currently in Environment Court mediation with the council in regard to that land.
And could you just repeat the number of houses projected there?
It's estimated between 2,000 and 3,000 houses.
Thank you.
The spatial plan includes household numbers or dwelling equivalent numbers for the entire southern corridor, which I can pull out in my closing submissions, but they're not specific to the Homestead Bay area, so they're less helpful, I think, to understand the context of the spatial plan. Just to put some timing around the spatial plan, it's been complicated by the fact that the spatial plan was released after the PDP decisions version and appeals were lodged. So something all the parties, including council, to the PDP appeals are needing to grapple with is how to deal with the spatial plan in the middle of an existing PDP appeal process. That's not a problem for the commissioners today, but just to give some context to the timing, the spatial plan is quite a recent document compared to the PDP. So my submission at 32, the correct approach is to assess the effects of this proposal against that anticipated environment. In other words, it would not be correct for the commissioners to consider the proposal against the environment as it currently looks. Rather, the commissioners must consider the site and the area surrounding the site, and that it's earmarked for urban growth by the PDP. And quite helpfully, the spatial plan really just adds to the direction the PDP takes this surrounding area anyway. It increases densities, but that residential outcome is sourced from the PDP itself. Would it assist the commissioners if I took you to the PDP structure plan at this point, or should I continue and?
Yes, that would be helpful. Thank you, Mr. Leakey.
So in the bundle, at the very back, so page 179. So this is an insert of Homestead Bay. Oh, sorry. You're fine. 179. Yeah, it's almost the last page of the bundle.
Thank you.
That's all right. I appreciate there's a huge amount of documents for this. But it provides some quite helpful context. So this is the decision version of the PDP. So it's now under appeal, but no appeals are seeking to downzone any of the land. So all the appeals are seeking either greater density over this structure plan or extension of the structure plan further up to the state highway towards the Remarkables. But just to orientate the commissioners, because quite unhelpfully, the structure plans don't clearly overlay landmarks, but the perhaps starting with the lake is the easiest reference point. The BFA is a marina proposal within the Homestead Bay Village. And the Homestead Bay Village sits obviously inland from that, and that's shown as VHB. This is the village where hotel development and apartment development is enabled. To the south of the village is the OSR South area. This is like the village. The OSR South zoning flows from the operative district plan. So this is already under construction. And OSR South is, they're large lots. I'm not sure of the size. It would be several hectares per lot, I think. And there's a large house under construction already in there. And as a visual output, that is the same zoning that the PDP places on this site. That way. Yeah. So that's Carmen's just made the helpful point. So we're moving to the north for our site, OSR North, which is if you move from OSR South through the village and come around the boating facilities area, so to the north, the OSR North is the access road that you would have driven down to get to the site, past the Jardines dwelling. And then the university proposal is right down by the lake at the bottom end of that OSR North. And OSF is the Crown-owned land and also some Jardine-owned land to the east of the OSR North land. And then the Jacks Point, the remainder of the Jacks Point zone is further to the north. So the structure plan village, the spatial plan, sorry, not structure plan, the spatial plan village would sit between this insert and the state highway, which is up by the Remarkables mountain range. And this is really the extent now of growth within the Southern Corridor. The Jardines have gifted the remainder of Remarkables Station, which is the land between the state highway and the Remarkables, to the QE2 Trust. And that gifting takes place in a couple of weeks. So moving to page 8 of my submissions, I'll move through these a bit quicker. There's no dispute that this is a non-complying activity. So there's the 2 gateway tests, the effects test and the policy test. In our submission, you can get through both of those tests, and then you move to 104. In terms of the policy test, I've quoted there the relatively recent and very helpful High Court case, which has found that contrary in relation to objectives and policies means opposed in nature, different to, or opposite, repugnant, or I can never say the last word, so I should stop putting it in my legal submissions. But whether an activity is contrary requires a fair appraisal of the objectives and policies as a whole. And I don't understand there's a dispute on that interpretation point as between Ms. Baker and Ms. Taylor. And as a consent authority, you must consider all the relevant provisions comprehensively. And if, as far as possible, reconcile them. In our submissions, and the evidence for the university demonstrates that adverse effects will be no more than minor, and that the proposal is not contrary to the objectives and policies. So moving briefly to 104, again, I won't read that out. One point which Ms. Taylor can speak to in her summary is in relation to the permitted baseline. A key part of the permitted baseline that is quite helpful are temporary permitted activities. It would be a permitted activity to hold 7 temporary events on this site in any year that does not exceed 500 people in attendance at any one of those 7. So a particularly relevant one and not dissimilar to what's been sought in terms of number of events, at least, by the university. Obviously, a much more refined cap on numbers of attendees. So we submit that the proposal to hold 31 large events, large being over 100 per year, should be considered against this permitted baseline. So moving now to effects, which I've provided a summary of the key effects. So at the time of the 42A report, as I interpret it, the key Points of disagreement on effects. There was one traffic point, which Mr. Kelly can speak to, around a sightline requirement at the access to the site. Secondly, cultural effects. Some points around conditions of consent regarding acoustic matters. And then what I understand are now really the key effects and disputes with council experts: landscape character and amenity, and wastewater. So starting with positive effects, in my submission, the proposal will result in a range of positive effects. It allows the university to utilise the site that's been gifted for the entirely philanthropic purpose envisioned by the Jardines to facilitate a meeting of the minds from New Zealand and around the world. The presence and intended use of the facility will attract visitors to the district, and it will be the university's first base in central Otago. And it will have likely flow-on effects for businesses and the economy through increased spending. It will enable publicly accessible educational activities such as open lectures, seminars, and community education courses for the district. And importantly, perhaps an indirect effect, but a positive one all the same, it provides for the retention of land on the shores of Lake Wakatipu that will not be subject to privatised residential development. And if the outcomes of the district plan were to be followed, this land would be subdivided for private residential development. In terms of geotech, Nigel Lloyd has assessed the effects. I understand there's no dispute with his council equivalent. Proposed condition 1 requires a site-specific geotech investigation to be completed prior to construction. And in my submission, this addresses geotech matters. In terms of transport, as I say, Mr. Kelly can speak to this. And I understand there's agreement with the council on transport matters. The 42A did raise a question of sightlines at the southern direction, towards the southern direction at the intersection of Homestead Bay and the private access road, and Mr. Kelly's responded to this in the third RFI response. And lastly, there was a question around passing bays that has also been addressed through conditions, and Mr. Kelly can speak to that. And I understand the council are in support of where that matter has landed. In short, 5 passing bays will be ensured through the conditions of consent, condition 19. Moving to cultural effects, starting with the gifting of the name, there's been extensive discussion and liaison and consultation with Ngāi Tahu. So consultation with Ōkaha began in the early stages, and they've prepared a cultural values assessment that was attached to Ms. Taylor's evidence. That concluded that the proposal is not inconsistent, with mana whenua environmental and cultural values. But Ōkaha did add, it's important that design outcomes and physical works are managed to ensure any potential adverse effects are avoided or mitigated. So in relation to those design outcomes, the university's been engaging with Ngāi Tahu in relation to design outputs for the initial stage, and will continue to do that for subsequent stages. And in relation to physical works, in my submission, the proposed conditions, in particular, the construction management plan and accidental discovery protocol, will ensure the effects on Ngāi Tahu are avoided or mitigated. Moving to acoustic effects. In our submission, the proposal ensures acoustic effects will be appropriately mitigated and will be minimal. Mr. Trevathan has provided a thorough assessment and concludes noise generated on the site will comply with the PDP noise limits. And due to the setback distance between construction and the nearest receiver being the Jardines, the construction activities will comply with the daytime noise limits without further mitigation. The breach of the PDP limits has been identified and is in respect to nighttime traffic movements in and out of the site. However, Mr. Trevathan, the council's acoustic experts, Styles Group, and Ms. Baker for the council agree that the effects of this nighttime breach are acceptable, and that the property, and also I'd add the properties they relate to are owned by the Jardines, who are in support of the proposal. Mr. Exeter from Stars Group and Ms. Baker have recommended a condition of consent regarding noise limits to and from the site. And Ms. Taylor will speak to this, but in my submission, it's not necessary. And in particular, it's seeking to control effects on unknown and unconsented future residential activities along the axis. And the reason we submit that is that the effect of the vehicle noise has assessed to be minimal. So even if future buildings were consented within that OSR North area along the axis, provided they're at least 15 metres from the road, noise effects on them are below guideline levels in relation to sleep disturbance. Therefore, that condition is not necessary. There's a practical reason as well. The proposed condition would result in complications in the future, as it may not be able to be complied with due to an unknown future dwelling that currently doesn't form part of that receiving legal environment. And it would leave the university in a position where it's unable to comply with the consent outside of its control. And I've just reiterated that. And then for that reason, it's not a reasonable outcome to condition that through this proposal. The third and more pragmatic point is that such a condition would be difficult to enforce, given the mixed number and exact timing of vehicle movements vary along the access road. They're not all university movements, and that minor exceedances of the condition would be unable to be predicted in advance or managed. So overall, in my submission in relation to acoustic matters, the combination of very limited acoustic effects caused by the breach of that nighttime limit for access and the complexity of the nature of the proposed condition results in it being inappropriate to impose at this stage. Stars Group, Mr. Exeter, has also suggested a stand-down period of at least 3 days between large events. And in my submission, that's also unnecessary. I've detailed why. There is a cap on the number of large events of 1 per week, and that essentially achieves, in my submission, the same thing, and that's condition 34B. So due to that, the applicant does not accept the additional condition around a 3-day stand-down. And overall, I'd seek that the commissioners accept the evidence of Mr. Trevathan regarding acoustic effects being acceptable and the conditions being appropriate to manage those. So moving to landscape and visual amenity, when considered against the existing environment, the anticipated landscape and visual context of the site and the surrounding area, in my submission, the landscape and visual effects are appropriate. Mr. Denny for the council and Mr. Espy have agreed in relation to several aspects, not all, several. The lecture theatre would not be out of character, subject to retention of trees. The site has an established context of buildings and landscape planting, and that the western portion of the site, so that's the site, the end closest to the hill, is visually contained and screened by existing vegetation. So the remaining areas of disagreement, as we interpret them, is the relevance and influence of the anticipated environment at Homestead Bay that I've spoken about in these submissions when assessing landscape and visual amenity. The capacity of the eastern portion of the site, so this is the site containing the subsequent staged visitor accommodation, to absorb the visual effects of the proposal, and a particular standard, which I'll come to in a minute, which is not complied with. So firstly on the vegetation, so perhaps to orientate this discussion, I'll go to Mr. Espy's landscape plan, which is in the bundle at page 31. This is also attached to Mr. Espy's. This is a Vivian and Espy plan, landscape plan, dated 26 November.
Thank you.
So the planting on the lake shown in the maroon or brown colour is not on university land. It sits on Crown-owned Lynn's land. And Mr. Denny raises a concern that that the eastern portion of the proposal will become prominent if these foreshore trees are removed. Now, my submission is highly unlikely that LINZ would remove those trees, given LINZ's purpose to ensure that Crown land is sustainably managed. However, given the university can't control that land and a condition can't be imposed to require the university to control that land, condition 14 has been proposed. And I understand this is agreed with Ms. Baker for the council. And it requires that in the event that the vegetation on the LINZ land is entirely or substantially removed, a landscape plan must be submitted detailing a revegetation regime within the site, and that this regime must achieve appropriate mitigation of visual effects when viewed from the lake and foreshore. And there's a small typo, sorry, that should be referring to condition 15, and Ms. Baker has agreed with that.
So take out the condition 14, Josh, and make it 15, Mr. Leakey?
Yes, that's right. Sorry,
Both
that should be,
references?
that should be 15. Yes. Yeah.
Okay.
Ms. Taylor's just checking that. Yeah, I've got the thumbs up. That's 15. So moving to the anticipated environment point in the context of landscape and visual, and I'll try not to repeat myself. As I've already outlined, the landscape and visual amenity effects are required to be assessed in the context of the anticipated development or the anticipated environment, sorry. And the PDP anticipates significant built form in OSR North, which is the land that contains this site. And in my submission, that's appropriate to be considered when you're assessing the effects of this proposal. Ms. Baker considers that while the wider setting of the site will contain substantial built form, the PDP does not set any expectation that this will extend to the open space activity areas. Sorry to jump around, but if I just go back to the structure plan on page 179 of the bundle, this is site clear. Ms. Baker is referring to the OSF area, which is to the east of the site. In particular, a lot of that is owned by LINZ. So we don't disagree with Ms. Baker that that land isn't intended to be developed. However, in my submission that this is the substantial development anticipated beyond that within the Homestead Bay activity areas to the south forms an important context for this area and for the consideration of effects. And further, Ms. Baker's assessment seems to have overlooked the development that's already located on the site. Mr. Espy describes it as a rural domestication, I think, and also the PDP decision version, which provides for up to 10 dwellings with associated flats within this OSR North area. And there's no minimum lot sizes in the OSR North area. And it would be logical if the land was developed for residential housing that those houses would be placed with the views of the lake. So on the subject site. So Mr. Espy identifies if the site was not earmarked for this proposal, it's very likely it will be utilised for further residential development due to the desirability of the location for residential activities. Mr. Espy's evidence goes into that point. Ms. Taylor's also, I won't repeat that, but provided more detail on the hierarchy of landscape protections within the Jacks Point zone, and I'll leave Ms. Taylor to speak to that in her presentation. So to conclude Ms. Taylor's view that while there are areas of open space anticipated within the zone, the OSR North, so the land containing the site, or the zone, this site, is at the lower end of the hierarchy of open space protection. And in my submission, this is my submission evidence from the bar, not Ms. Taylor's evidence, this is visually demonstrated by the existing OSR development further to the east, so OSR South, which has already been subdivided and sold down and is now under construction. And that provides a visual example of what OSR North would look like if developed. So looking to the eastern part of the site, which I understand is a focus of Mr. Denny's concern, while it's accepted that the eastern buildings will be more visible from the lake than the western buildings, they will be visually softened by existing and proposed vegetation. So it'd be best to go back to Mr. Espy's landscape plan on page 31. The large or long building at the east of the site is the proposed visitor accommodation wing, which is part of the subsequent stage of the development. And the mitigation planting we're talking about there is shown. Mr. Espy will speak to it in more detail, but further to the east from there. In my submission, these buildings will be visually softened by both the existing and the proposed vegetation in the strongly vegetated setting. Some amendments have been made to the proposal in response to Mr. Denny's feedback, and I'll briefly summarise those. There is the comprehensive landscape plan that's ensured through the conditions of consent, and in addition to new planting, it also requires the retention of existing planting where that serves a mitigation purpose. And Mr. Espy's identified that planting on the landscape plan. And as I say, it also proposes considerable new planting to mitigate effects. One change, which Mr. Ritchie will speak to, is that the colour of the cladding of the new buildings has been amended since the notified version. It's now proposed to be stained black as opposed to silver grey. This is a recommendation of Mr. Denny's that the applicant accepts. And this will further reduce potential visual prominence from the lake. So in our submission, that the proposals, the concerns of Mr. Denny have been appropriately addressed, and the eastern portion of the proposal will be suitably absorbed into the environment. I won't read out the next section. It's further detailed in Ms. Taylor's evidence, but it relates to a rule requiring 50% of a site in this zone to be planted in native vegetation that is triggered due to this land being in the OSR North. And for the reasons I've outlined there, and we submit that failure to comply with this does not result in more than minor effects. Probably the only point I'd like to emphasise from my summary at 72 is that this site is quite different to the remainder of the OSR land within the Jacks Point zone, and that it already contains existing development and existing vegetation. So quite different to OSR South, which is the land I've been pointing you to further to the east, the southeast of the site, which is blank pastoral land where this 50% rule of planting also applies. So I've summarised that at subparagraph D at the top of page 18 there, where I've just mentioned that unlike the majority of the OSR land, this site is domesticated and features existing buildings and dwellings enclosed by extensive gardens and landscaping. And it's therefore dissimilar to the surrounding OSR land. Then at 74, I've just concluded on the landscape and visual, which I won't repeat at this stage. So moving to the second key point for today, which is the servicing, in particular wastewater. The evidence for the university demonstrates the site can be appropriately serviced. There's a bore on site that has been tested and will provide appropriate potable water. And proposed condition 13 requires a connection to be made to a wider water reticulation scheme when that comes, as is required by the spatial plan. And the council's engineer has accepted, and as I understand it, there's no disagreement on any servicing matters between Mr. Lloyd and the council. The only outstanding matter is a planning and legal one, really, which is the proposed servicing of the wastewater infrastructure. I've already gone over that, but to briefly, as the reticulated wastewater system is currently not available in the area, the university proposes to develop the application in stages. And
Excuse me, Ms. Baker, could you please mute your, thank you.
I'll just start again. Sorry, I got slightly distracted by the dog. The stages, there's the initial stage being the redevelopment of the existing buildings and using an on-site wastewater storage and trucking solution. And then the subsequent stages being the new build parts of the development once that reticulated wastewater is in place. So Mr. Lloyd will speak to the potential sort of location and operation of that wastewater solution. There's certainly evidence that it's a feasible solution. It would involve a buried wastewater holding tank that would be emptied by a tanker, and it would equate to approximately 1 truck movement per week if the proposal was operating at 100% of the initial stage usage. So Mr. Lloyd's concluded that the proposed wastewater solution is feasible and appropriate. And the council also agrees that the effects of the proposed wastewater servicing are minor and acceptable. However, they raise questions about the proposed management of the subsequent stages, which is what I've focused on in this section. So the condition precedent, which is 9B, it's probably helpful to go there now. 49 of the bundle. Thanks, Carmen. So this condition's in Ms. Taylor's evidence as well. So condition 9 has 2 subparts, A and B. I'm just ad-libbing here, sorry, but (9A) relates to the initial stage of the development, condition 9A. It may be constructed and occupied from the date the consent or another condition is complied with, so essentially initially. But in response to Ms. Baker's report, the subsequent stage condition precedent has been amended. And this now clarifies that the construction of the subsequent stages cannot begin until the council begins construction of the area-wide reticulation. So this is to avoid any potential or albeit unlikely situation where the university were to construct the subsequent stages, but the council were to not construct the pipeline and the university be left with buildings that can't be occupied. So that's the purpose of that amendment, is to ensure alignment between the subsequent stages and the reticulated pipeline. In my submission, this addresses the concern raised by Ms. Baker that the subsequent stages could be constructed and remain vacant. So this is a condition precedent approach. And in my submission, it's entirely legally valid and appropriate, and is a good pragmatic solution to ensure that this project gets off the ground, essentially. It's well established in case law that a condition that defers the opportunity for an applicant to embark on an activity until a third party carries out some independent activity is lawful and valid. I've quoted there the Marlborough District Council case, which involved Hector's dolphins. Less relevant really than it enforces the same precedent, but probably the key case is the Westfield case over the page in relation to in a land use context. It made a similar finding as the Marlborough case, holding that a condition precedent which deferred the opportunity for an applicant to embark was lawful and valid. The High Court in that case confirmed that there was nothing objectionable about a consent condition resulting in such an outcome. So that case there, which involved a Westfield development in Hamilton, required off-site road works, including a road closure by NZTA, to be completed before the application aspects of the application could be occupied, and the High Court said that that was an appropriate approach. And that's akin in my submission to this situation here. The applicant would be, it's appropriate for this subsequent stages to be conditioned, awaiting that reticulated wastewater solution. So the effect of the proposed condition is that the ability of the university to occupy, well, in fact, construct, sorry, that should say, the subsequent stages is deferred until the reticulated scheme is under construction. However, the consent itself and the initial stage will take effect from the date of issue. In addition to the condition being lawful, the provision of certainty is key when considering whether a condition precedent is acceptable. So I've just summarised that at 82, as in what is the certainty of this reticulated wastewater scheme coming into place. And in our submission, the proposed condition provides appropriate certainty. It will allow the initial stages to occur as soon as possible, despite potential delays in the provision of reticulated services. And that's entirely within the control of the university to carry out and undertake the initial stages. For the subsequent stages, so at B, there is sufficient certainty in my submission, and for the following reasons. Initial scoping work's been carried out demonstrating that reticulated wastewater services to the site is practical and can be achieved. Funding for the wastewater services is included in the council's long-term plan. I've referenced the long-term plan there, but just to expand on that orally, sorry, there's scoping funding started last year for wastewater provision on the Southern Corridor, and construction funding is included in the long-term plan for years 2028 to 2031. Further, the Southern Corridor was included in the Spatial Plan as a key urban area, as I've outlined, and it identifies, that is the Spatial Plan, the provision of reticulated wastewater and water in the next 4 to 10 years. The Spatial Plan was released last year, so the next 3 to 9 years. And in our submission, this provides certainty the council will prioritise the provision of services. I just add to that as well, the outcomes of the Spatial Plan will ultimately need to be delivered for the council to ensure it achieves its obligations under the MPSUD regarding the release of residential land for housing, and that the Southern Corridor is relied on in the future by the council, subject to the provision of that wastewater. But to refocus on today and this proposal and these conditions, proposed condition 9B, as I say, has been redrafted to ensure that the construction of the subsequent stages can't commence until the timing of the required wastewater for the reticulated scheme is known. So there's no risk of vacant buildings. I won't read 83 and 84. I've just expanded there that this is a sensible solution to ensure that this project, the initial stages, can be undertaken. There is an appropriate wastewater solution for those, but the university can have the certainty of the grant of a consent to start planning for those subsequent stages to ultimately align with that wastewater pipeline. So 85, for all those reasons, in our submission, there's no legal or planning barrier for the council to grant consent for the proposal based on that proposed condition precedent. At the time of the 42A, Ms. Baker did raise some concerns about insufficient information to assess the effects of the proposal in relation to wastewater. We submit that the commissioners now do have sufficient information to grant the consent on the basis proposed. And really, the crux of it is, if the proposed reticulated wastewater system is not available or doesn't happen, the subsequent stages won't be able to be constructed. That risk sits entirely with the university. But even in that situation, significant positive effects will be able to be generated through development of the initial stage, which is the whole intent of this staged approach. At 87, I've just tied that off against the law, which I've already gone over, so I won't repeat. So moving now to the district plan assessment. To get through that policy test, obviously, the proposal must be not contrary to the objectives and policies of the PDP and the ODP. In our submission, the proposal is consistent with both. And in that sense, there's no need to look to weighting. In my view, I've included a section within the legal submissions on weighting, but given the proposal is consistent with both, in my submission, there's no need to weight. They head you in the same direction in the context of this proposal. So briefly, starting with the operative district plan, to the extent that remains relevant, the proposal is consistent with the objectives and policies. I've outlined that at 95. And Ms. Baker agrees the proposal is not contrary to the ODP as a whole. And in relation to the PDP, where there's more disagreement between Ms. Taylor and Ms. Baker, in our submission, the proposal is consistent with the objectives and policies of the PDP, and Ms. Taylor's set that out comprehensively in her evidence, and I've just attempted to summarise the key aspects here. So starting with Chapter 4, Urban Growth. A key focus of Chapter 4 is to ensure that urban growth is in locations that are within the urban growth boundaries. So Chapter 4 is the result of an Environment Court decision. So it's been through court mediation and hearing. The existence of the urban growth boundary around the site, as in we're within the urban growth boundary, is therefore an important distinguishing factor in terms of what the PDP anticipates for this site. The urban growth boundary provides a policy direction through the PDP that the landscape character of this site is going to change. In relation to the landscape chapter of the PDP, the site's not within the rural zone, where Chapter 6 imposes quite specific policy protection for landscapes. It's within the Jacks Point zone. And by virtue of the Jacks Point zone being within the urban growth boundary, the site is confirmed by the Environment Court to be carved out of that more restrictive policy framework. We've provided a short summary of the Jacks Point zone provisions. They're quite complex and broad. I've included them within the bundle from page 120. But at a high level, the purpose of the Jacks Point zone is to provide for residential rural living, commercial, community, and visitor accommodation in a high quality, sustainable environment. In my submission, the proposal meets that intention as it provides for commercial and community activities, as well as visitor accommodation in a visually sympathetic and sustainable manner. And it's an appropriate reuse as well of an already modified part of the Jacks Point zone. In fact, it's likely to have been the first part of the Jacks Point zone to have any modification over 100 years ago. Ms. Taylor's evidence is that the proposal is consistent with the key objectives and policies of the Jacks Point zone that are relevant. And I'll leave Ms. Taylor to explain why that is. Ms. Baker considers the proposal is inconsistent with one particular policy because the proposal is not in accordance with the Jacks Point structure plan. But importantly, Ms. Baker, as I read it, her conclusion is it's not inconsistent to the extent to render the proposal contrary to the PDP when considered in the round. We agree with Ms. Baker that the site is effectively zoned for low density residential development through the structure plan. However, in our submission, Ms. Baker's view that the proposal is inconsistent with the structure plan overlooks the existing environment on the site that includes several existing buildings that predate development of Jacks Point and the Jacks Point zone. And it also provides for the use of the woolshed and the site for events of up to 7 a year. That's the district plan, that is. We submit that the result of the combination of the existing environment and also that permitted baseline of the 7 events and residential development outcomes is that the proposal is not inconsistent with the structure plan. Moving to natural character and conservation aspects. Now, submission, the proposal is consistent with the PDP objectives and policies around these aspects, and Ms. Baker has assessed that also. Ms. Baker's view is that the proposal is inconsistent with in a particular objective and policy set because the application doesn't include 50% of the site being ensured and native vegetation. I've touched on this earlier in my submissions. In our submission, we agree it doesn't, but that the 50% native vegetation is not required for the proposal to align with the relevant objectives and policies. I've just provided some more detail on that already. I won't repeat that at 107. Ms. Taylor's also assessed that in her evidence. More relevantly in my submission is the servicing discussion around the PDP objectives and policies. So the site and the wider area are identified as a key growth area in the spatial plan. And while wastewater reticulation's not yet under construction, it's planned through the relevant council planning documents, including the long-term plan. And in this respect, in my submission, the development of this site is consistent with the particular objective 222A and associated policies that require development to be coordinated with efficient provision, use and operation of infrastructure and services. So that's a point of disagreement between the applicant and the council. In our submission, Ms. Baker takes a too narrow interpretation of this policy framework and coming to the conclusions regarding consistency. The spatial plan, as I say, will ensure the wastewater provision and the long-term plan. Both policies identify urban development and servicing for the wider area that contains the site. Further, and equally relevant, the site is planned and zoned for future urban development and is within the urban growth boundary. All relevant matters for your consideration. In my submission, what that particular objective is in fact seeking to do is avoid fragmented infrastructure investment where a development is proposed in, say, an isolated rural area separated from planned development. That's not the situation here. And it's not a requirement of that objective and the associated policies that infrastructure be in place before any resource consent is granted. Rather, the policies refer to integration with existing or proposed, and I've italicized proposed probably for obvious reasons, infrastructure. The development of the nature of the proposal on the site is also important to that assessment. And in relation to Chapter 27, which is a subdivision chapter, the primary purpose of Chapter 27 of the PDP is to ensure that subdivision will enable quality environments to ensure the district is a desirable place to live. And in that sense, it's important, and I've reiterated this already in my submissions, that the proposal does not seek to subdivide the site, but seeks the redevelopment and extension of existing built form on the site. And that's an important distinction when applying this proposal to other future, most likely subdivision proposals in the Southern Corridor, but prior to wastewater reticulation being provided. Slightly different topic, but linked to that is the question of precedence and plan integrity, which is also raised as a concern by council around the grant of this consent prior to reticulated wastewater being provided. In my submission, such issues don't arise in this case. That the case law I've quoted in my submission gives you comfort that the approach, condition precedent approach, is appropriate, deferring the opportunity for the university to do the subsequent stages until the pipeline comes in. And in my submission, the proposal is consistent with the objectives and policies relating to subdivision and development that Ms. Taylor's also assessed and I've briefly summarised. And even if there were precedent or plan integrity matters of concern, they're unlikely to develop into an issue here because the proposal is unique and it's an appropriate adaptive reuse of an already domesticated areas. And there's no other areas within Homestead Bay, or indeed I'd say the wider Queenstown district where that's the case. Particularly when considering this proposal, which is for the wider public benefit in terms of an educational facility, as opposed to a private residential development that inevitably involves a subdivision. As such, effective precedent arguments are unlikely to result out of the granting of this consent. And indeed, if they did, and this proposal were to create a precedent for lakefront land being gifted for educational purposes, that wouldn't necessarily be a negative effect. I briefly touched on the higher order planning documents. In my submission, they're not of any particular moment in relation to the contentious parts of this application. Likewise, I can move through part 2 relatively briefly. At 117, I have noted that as the PDP is subject to appeal and the policy framework is not yet settled, it is still appropriate to refer up to part 2 in relation to the PDP. And the evidence of Ms. Taylor is that the proposal is consistent with part 2. And that's a point of difference between Ms. Baker and Ms. Taylor. But in our submission, and as I've outlined at 44 of these legal submissions, the proposal will result in a range of positive effects that will enable the community to provide for their social, economic and cultural well-being while sustaining the potential of natural resources. And that's entirely in line with part 2 of the Act. The community will benefit from the proposal through publicly accessible educational facilities, increased visitor expenditure and retention of lakeshore land that will not be privately developed. Unusually, but in my submission quite tellingly, there's not a lot of submissions to deal with in relation to this proposal. One from Heritage New Zealand. There's the Jardines, which the Jardines will speak to themselves. Heritage New Zealand and Karunaka. I've already touched on the Ngaitahu response, so I won't repeat that. I've just summarised it there for completeness. And also Heritage New Zealand, the key point there being that if an archaeological authority is required, which is likely, that will be obtained separately to this process, which is entirely appropriate. So just to conclude, the proposal represents a unique opportunity to develop an internationally recognised education facility in the district, and it will provide significant public benefit from the generous gift from the Jardines to the university, which will generate these positive effects for the district. In my submission, the proposal meets both the gateway tests, and that's supported by the evidence on behalf of the university. And the commissioners can be satisfied it's appropriate to grant consent subject to the conditions which are attached to Ms. Taylor's evidence and in the bundle. So I've outlined at 129 the order I'm proposing to call the university witnesses, and I am in the hands of the commissioners if you have any preference there, but happy to take questions now or throughout the day as the witnesses present their evidence.
Thank you, Mr. Leakey. I think while it's fresh in our mind, I'll check with Commissioner Sinclair if you have any questions for Mr. Leakey. I have some myself. So, Commissioner Sinclair, would you?
Thanks, Mr. Leakey. Thorough submission, so you have taken out a few of my things that I had on my list. There's one thing I just wanted to ask you about. The application refers to a 10-year consenting timeframe. How does that work in relation? There's not much in the evidence on the reasons why that's applied for. But there's something I wanted to talk to you about was how does it work with the stage development and the fact that this reticulation might not go in for 9 years?
Yes, no, I understand the question. So that's condition 2 you'll be referring to, Commissioner Sinclair, I assume, which is the lapsing date. So a longer lapsing date has been sought than perhaps the standard of 5 years. So the consent shall lapse 10 years from commencement date. So that would be if the consent was not given effect to the date that the consent would no longer exist. And in terms of the staging, once the initial stage has been given effect to, then the consent in its entirety will have been given effect to in my submission. So the lapse date will be a thing of the past. It won't be a point anymore. So in a mechanical sense, what's sought is a 10-year period, conservatively I'd add, for the university to give effect to the consent, which would be the initial stage. And then that would and doing that give effect to the entire consent. So the staged approach wouldn't change the test for whether the consent's been given effect to. And that once you've given effect to part of the consent, you've given effect to the whole consent.
Thank you. The other question
Sorry, just while we're on the subject of that, is there any case law or guidance on the appropriateness of a 10-year lapse date, as it is longer for land use activity as opposed to...
That's a good question. I'll look into that. I'm not sure off the top of my head. I'm sorry, I can tie that off in closing submissions. I mean, the intent behind it was to give the university appropriate time to get the application together, but I can provide some more authority on the judicial treatment of that.
Because one thing that crosses my mind is that we have the appeals and the PDP, and as you've made the point that no one's seeking to make it more restrictive, it could change, and then if we have a 10-year lapse date, the appropriateness, but I take your point about once the initial stage is given effect to it, it won't lapse. But it would be helpful to understand the appropriateness of the 10 years.
Yeah. And I understand the question. I'll add that to our list.
The other question I had was just a bit of help on clarification. The Jardines have supported with their supporting submission, but they haven't given an APP. At what stage can we disregard effects for talking in terms of the Woolshed Road issue and the traffic noise at night?
Yes, so the Jardines have never been asked to give an effective party approval. So just to confirm that's correct, there's no effective party approval from the Jardines. So that the effects on them need to be part of your assessment. But in my submission, their support of the project and their view on those effects is a key aspect for your consideration of the effect on them and the appropriateness of that effect. So to answer your question, in my submission, you still need to consider the effects on the Jardines. And also the fact that the second property is occupied by people, although it's owned by the Jardines, is occupied by employees of the Jardines. So you'd also need to consider the effects on them. So the view of the Jardines is relevant to your assessment, but it doesn't mean you can disregard effects on any of the Jardine-owned properties. The Jardines still aren't here, but I'm sure they'll have a very pragmatic response to your question if you put it to them.
The other question I had was this issue of the zoning, and we've got the site, which is the education facility proposed, and then the zoning behind it allows up to the 10 residential units of large lot.
Yeah.
And then it was just your comment in your submission that if the proposal doesn't go ahead, could houses be built on that site? Would that be part of the 10, or is that would that be additional to the 10?
Yep. So that would be that would include. So the 10 is a total for the entire area. So that 10 would get split between any land within OSR North. I think it'd be helpful for me to clarify that example I gave, or that is a pure planning example. In a real life sense, just for the record, the gifting of the land would mean that it wouldn't be subdivided for residential use regardless. It's a planning baseline type argument I'm running there. Yeah.
Thank you. And the last issue I had was on site yesterday. We could only find 2 profile poles for the lecture theatre, and I'm just wondering, with 4 profile poles, we found the 2 most western side, but we couldn't find the most eastern side, just underneath before it goes into the ONL. And were ever 4 ever erected?
I think those poles might be for the service shed or the bike shed.
Oh, okay.
There. And then maybe no poles for that.
We can look into that, Commissioner Sinclair. What Mr. Lloyd's saying is that potentially there for the ancillary buildings, and that there weren't profile poles for the lecture theatre, but we'll double check what was put in.
There were poles put in,
Oh.
but I don't know that they're still there. They might have been removed from wind issues.
Okay, we'll look into that.
The two that were there looked like it was the lecture theatre.
They were by the sharers' quarters too, we could see, but so I think perhaps two are missing. And then there was the cluster down by the visitor accommodation are all intact still, but I think there was some missing by the lecture theatre, potentially. But if you could clarify.
We'll clarify what the poles that are there are for, and that, it may be that the lecture theatre ones have been removed.
They were put up again in about when Mr. Denny went back to site for his revisit. So
prior to the 42A report being released. Yeah.
That was all I had, Mr. Leakey. Thank you.
Thank you. Mr. Leakey, I had some questions following on about the point you've made about this having a public good, the development in comparison with a private residential development and subdivision. And one of the questions that occurs to me is, if it were to be a residential development, would there be a requirement for an Esplanade reserve along the lakefront? Or are there any rules requiring any vesting of land if such a development was to proceed?
Well, there would be. Yes, sorry, I didn't mean to cut across, Commissioner. The RMA's statutory baseline requirement for an Esplanade reserve would be triggered on subdivision. I would want to just double check the implication of the fact there's existing Crown land between the lake bed and the subject site, which may have an impact on that. But I'll double check that point and include that in my closing. But certainly if the subdivision was to take place immediately adjacent to the lake, then that would trigger the Esplanade reserve requirements.
Yes, and I did wonder, and it's probably a question from Ms. Taylor and Ms. Baker, whether there's anything in the subdivision chapter about that, a specific rule. But obviously it probably does not abut the lake, but whether there was any expectation or standards relating to that would be helpful to understand.
Ms. Taylor's making a note, I see, so we'll be able to check back on that subdivision chapter.
It may not be relevant, but I was just interested in the comparison that you were setting out.
Yeah.
One of the things you've talked about is the OSR North being lower in the hierarchy and in your submissions, and I was just trying to understand the concept of the hierarchy. Where is this guidance and a concept of a hierarchy taken from?
I understand. The Jacks Point zone has a huge number, sorry, huge is a strong word, a number of open space areas. There's open space golf as one example, where which is the existing golf course, but also the large ONL land behind the site. And it's not a prohibited activity, but it would be very difficult under the objective and policy framework and then rules to establish, say, a residential or any building or any built form in that OSG area. Likewise, OSF, which is the part of the structure plan Ms. Baker did refer to, is a similar treatment. There's no anticipation of dwellings or domestication in that area. So in that sense, when I'm talking about a hierarchy, there's more protections around that open space outcome and that part of the structure plan. Then the residential open space areas, relevantly here OSR North, but also OSR South, where the Chapter 41 framework anticipates built form. So it anticipates an eroding of that open space through the rule and then the objective and policy framework. So it's less protected, if you like, than those other open space areas. So that when I'm talking, when I talk about a hierarchy, that's what I mean there. There's less focus on pure protection in these residential open space parts of the structure plan, than there are in other parts of the Jacks Point structure plan.
Thank you. Now, just sorry, going back to that concept of the privatisation by residential development, you said at your paragraph 2044, would the proposal enable general public access, or would it only be through invitation to events and so forth?
So it would be through invitation to events. So it wouldn't be the equivalent of a public reserve. And the Tanya and the university witnesses may have some comments on this. In practice, at other university sites around the country, that they're not gated or locked, so people do use them for thoroughfares. But this and that may result here, but as a for the commissioner's purpose, for what you can rely on, it won't be an area where the public have a right of access or a right of entry. It would be invitation only to events. And that would be controlled. One of the reasons there's the caretaker house is to have someone on site to help manage that.
Thank you. One slightly interesting matter, when we walked over the site yesterday, we noticed a fairly wet seepage area through the VA part of the site. And I wondered, and this is a question for perhaps the planning witnesses, the relevance of the NES freshwater and any evaluation of whether in fact there are wetlands on the site, and is this relevant to our consideration?
I've made a note of that. I'm not familiar with there being any assessment done in relation to the site. I know there's been broader ecological assessments done around potential wetlands when different wastewater options were being considered around the broader Jardine property for this proposal. But we'll report back, but as far as I know, there hasn't been a particular wetland assessment done in relation to the site. Yeah, Mr. Lloyd's pointed out it has been very wet lately. But we'll make a note and we can report back potentially through Mr. Lloyd on that.
Thank you. And I think so. One of the key matters in contention is the difference between Mr. Espy and Mr. Denny with the relevance of the anticipated environment. And from your submissions, you have set out quite at least something the anticipated environment, and it's also addressed in Mr. Espy's evidence. Is there a difference between the environment of the site and the wider receiving environment? And in that case you've referred to at your paragraph 28, are we able to consider, this talks about what exists and what's anticipated, is that referring to the site or the surrounding area or both? Because there is a difference perhaps.
Yes, no, that's a good question, and in my submission it would be both. Where the anticipated environment is a different proposition to the sort of permitted or a baseline type environment. In my submission is that the anticipated environment just provides you, and so starting with the off-site anticipated environment, it provides you with a lens or a context against which to assess effects. It doesn't suggest you can disregard effects just because they're anticipated. It just provides a context to the assessment of those of those effects. And that's different to an on-site baseline, permitted baseline submission, which I'm not making here other than the temporary activities, where we'd be seeking you as commissioners to disregard those effects. So that's my view on or my interpretation of the difference between an on-site baseline argument and a broader anticipated environment. In terms of the anticipated environment, in my submission, it applies equally to activities on the site and assessing those effects and activities off the site. Just with the proviso that it's not saying you don't consider those effects, it just provides a context or a lens against which to consider them. I mean, the Frost case was around effects on neighbours. So the effects that those neighbours, or the type of activities those neighbours should anticipate from the district plan. So in that sense, it was applying the effects of a proposal off the site to the neighbours, and that's an equivalent situation here, just a much larger scale.
Thank you. So I think I've got one more question about oh no, I've covered that, the lapse date. No, that's all now. We're at 10:37 and we've had proposed a short break at 10:30. So would it suit to take that break now before you introduce?
Yeah, I think that would be helpful if it's okay. If we just took a short break and then I could call the first university witness.
Okay, I'll just check with you.
Yeah, thank you.
Thank you. So now break till let's say 11 or 5 to 11, 10:55. Yeah.
Sure. Thank you.
Thank you. Yes, here they are.
I'll move to call our witnesses if that's okay by the commissioners.
Yes, thank you, Mr. Leckie.
So our first witness is Ms. Siddell for the University of Otago. Ms. Siddell has a minor correction to make to paragraph 30 of her evidence, and then has a summary statement, which you've seen, which she'll present. So if we could just pass to Tanya to explain the correction, then we'll go to the summary.
Yes, thank you. Good morning, Commissioners. So the correction to item 30 in the statement of evidence file should read, should consent be granted, the components included in the subsequent stages will not be able to be constructed until it is confirmed that the facility will have a connection to wastewater infrastructure.
That was one less question I had for you. Thank you.
It was just a test, commissioners, to see if you read it. I'll pass to.
Excellent. I'll read my summary statement now. So my full name is Tanya Lee Siddle. I'm the Director of Campus Development at the University of Otago. I have the qualifications and experience set out in paragraph 2 to 6 of my statement of evidence. In this statement, I provide a summary of the key points in my evidence and respond to the evidence provided for the council, which I have read. Key points. In 2016, Gillian and Jardine gifted the university the 4-hectare Woolshed Bay property at Homestead Bay. The site is located on the shores of Lake Wakatipu in Woolshed Bay at Jacks Point. The site currently holds a residential building, a twin villa house known as the Shearers Quarters, historic dog kennels, and a set of covered drafting pens and extensively landscaped gardens. The Jardines and the university agreed that the site would be developed as a research retreat for academics. Between 2017 and 2019, the university has considered and evaluated potential uses for the site to meet the gifting intent of the Jardines, which has resulted in the final proposal for Hakitakura. The proposed development for Hakitakura involves the redevelopment of the existing residential dwelling known as the Woolshed into a public building and educational meeting venue, and the demolition of the existing Shearers Quarters and the construction of a lecture theatre in its place and construction of visitor accommodation units and other ancillary buildings. The development will be constructed in stages. The initial stage involves the redevelopment of the existing Woolshed building, the construction of a staff residence, and additional features not requiring a connection to wastewater. The subsequent stages involve the construction of the lecture theatre, the construction of the visitor accommodation units, and any remaining facilities. The lecture theatre will be constructed in a staged manner adjacent to the coveted woolshed and with a covered walkway between the two buildings. The redevelopment of the woolshed will accommodate 60 guests initially. In the future, the subsequent development stage will allow for a maximum 120 guests. The university intends for Hakitakura to meet the New Zealand Building Code 5-star Green Star accreditation for the subsequent development stage. Due to wastewater constraints, the university has proposed to carry out the development of Hakitakura in stages. The staged approach provides the project certainty while managing wastewater effects. The initial stage will be constructed and used before connection to reticulated wastewater is installed in the area. This stage will be serviced by on-site reticulation to a holding tank and will have a holding capacity of 20 cubic metres to account for small and medium-sized events. The development of the necessary reticulated wastewater infrastructure to the southern corridor has been identified as a deliverable and feasible option in the Queenstown Lakes District Council long-term plan. Staging the development allows for the grant of consent and for an initial part of the development to commence operation despite potential delay in the provision of these reticulated wastewater services. Hakitakura has been shaped by an experienced consultant team who have provided an innovative and thoughtful design solution, ensuring that Hakitakura integrates itself into the wider landscape. Hakitakura is an exciting opportunity for the university to establish a base in the Queenstown Lakes District and advance the university's mission through strong external engagement and commitment as a local, national, and global citizen. Thank you.
Thank you.
Do you have any questions? I've just got a couple of questions. Thank you. First of all, I'd just like to thank the university for the submitting of the cultural values statement. We don't receive them very often, and I found it really interesting to read. So thank you for that. The second question I had was just about the private bookings for functions and weddings you do quote, and just how the university intends to manage those, and would they be responsible for making sure those types of functions run in accordance with any conditions of consent that are imposed? Who will be responsible for those?
Sheila?
Good morning, Commissioners. I'm Sheila Murray. I'm zooming in from Dunedin as I've got the flu. So the running of private events will be managed by the on-site manager. So we are planning to have an on-site manager living at Hakitakura, and the running of all events would be along the lines of the agreed use of the facility and the university's rules when it comes to running of events.
Okay. The other question I had was with the the accommodation units. Can they be rented as normal visitor accommodation, or do you have to do the function and then stay at the accommodation unit, or will you run both systems?
Josh, you may be able to, our thoughts are that we aren't envisaging it will be able to be privately booked for accommodation only. We are thinking at this stage it'll be more aligned with them using the facility and being there for an event. There's been no discussion with the university about having private accommodation available as an option outside of an event. Josh, did you want to add to that?
I can put the planning and legal lens on that. As I understand it, there's not that intent, but the conditions don't restrict or don't specify or control who uses the visitor accommodation. So it would be consistent with the consent for someone to use that accommodation and not be at an event within the lecture theatre complex. So there's no restriction proposed, but as Sheila's mentioned, that's not the university's primary driver, but the consent, as it's proposed, would enable someone to stay in the accommodation and not be at a lecture. So there's no link there in a condition sense.
Thank you. That was all I had.
Thank you. I'm not sure if this is best directed to Ms. Murray, perhaps, or Ms. Siddell, but I did wonder, I noticed the date of gifting was in 2016, and was the university involved in any of the PDP in terms of submissions on the zone or appeals? Mr. Leakey has told us about the Remarkable Station appeal. Did the university have any involvement in the proposed district plan, given the intention for this land to be gifted and developed in the future?
I can respond to that question if that's okay, Commissioner Dimery. When the university was gifted the land, they became a successor. So they inherited the Remarkable Station submission in relation to this land. So I'm acting for the university in that context on the district plan review. We settled with the council in relation to that appeal. It related to the council and some other parties, it related to the ONL line. The university supported the council's position of the ONL line, which is where it is now. Some other parties had sort of been moved, but that was resolved. So a consent order has been issued on that. So the university has no active involvement in the PDP now. And while it predates my time as well, the university didn't have involvement in the original submission lodged by the Remarkable Station Limited advisors. That was entirely prior to the university's involvement. So the university, if you like, inherited that position when they were gifted the land.
Thank you. Supplementary question.
Oh, thanks, Mr. Leakey. Just regarding that ONL line, I take it that's the line on the Jacks Point Knoll. Mr. Denny has raised a slight issue with the ONL line on the foreshore. Were you talking about the same line, or is that a different issue?
That's a different issue. So the ONL line dispute and then resolution through the PDP was in relation to the open space golf land and behind the site. So it was that interface. The PDP hasn't touched on the lakeside ONL point. So that's a separate one, unrelated to the PDP.
Thank you.
Thank you. I don't have any further questions.
And neither do I. Thank you.
Thank you very much.
Thank you, Commissioners. That's a nice segue now to formally introduce Sheila Murray, who's the next university witness. Sheila's prepared evidence and also a summary, so I'll pass to Ms. Murray to present the summary and take any further questions.
Thank you, Commissioners. My name is Sheila Ann Murray. I'm the Director of Development and Alumni Relations at the University of Otago. I have the qualifications and experience set out in paragraphs 2 to 6 of my Statement of Evidence dated 27th of May 2022. In this statement, I provide a summary of the key points in my evidence and respond to the evidence provided for the Council, which I have read. The university was established in 1869 and is New Zealand's oldest university. The university operates its main campus in Dunedin, but maintains a nationwide presence with campuses from Invercargill up to Auckland. Ko te Uwanarantanga, the university's mission, seeks to create, advance, preserve, promote, and apply knowledge, critical thinking, and intellectual independence to enhance the understanding, development, and well-being of individuals, society, and the environment. The university strives to continue to advance its research culture and ethos and to address questions of national and international importance, along with remaining at the forefront of New Zealand universities in teaching and academic performance. In 2016, Gillian and Dick Jardine, the owners of the Remarkable Station, gifted the university a 4-hectare property located at Woolshed Bay on the shores of Lake Wakatipu. Since 2016, the university has worked with the Jardines towards developing the site as a sustainable centre for research and teaching, while respecting the wishes for the site and the Jardines' connection to the site. This collaboration has resulted in the proposal before the hearing panel today, Hakitakura, which will attract academics from New Zealand and around the world to Queenstown and provide for their needs whilst at the site. In February 2019, the university was gifted the name Hakitakura by Ngā Tauhu for the site. Otago Apuku Edward Allison said gifting the name of prominent tupuna was not a decision they made lightly, as it was a highly valued tonga, a treasure, and a special ceremony was held to announce the name and reveal a carving by the artist Ricky Namoki on the site, and you would have seen that carving when you visited the site yesterday. Hakitakura will primarily be used by the university and its staff for academic retreats, conferences, and to host events. Gatherings of up to 60 people will be accommodated within the former woolshed, while formal lectures and other academic focused activities will take place in the adjacent lecture theatre. The operational requirements of Hakitakura means that approximately 5 staff members will be required to run the facility. 1 will reside on site, Private bookings for events such as weddings and meetings will be available by prior arrangement to ensure economic viability and to support local community groups. Hakitakura will result in a range of positive effects for both the university itself and the Queenstown Lakes District. These being strengthening the university's strong and visible research presence, focusing on impactful community engaged research, fostering collaboration with local communities. The university has recently developed and implemented a strategic framework to have a visible, enduring and impactful presence in Central Otago and Southern Lakes, and this will be formally launched in September of this year. Providing the university with a base in the Queenstown Lakes District is something that it has not had to date. This will enable new and strengthened connections with schools, businesses, iwi and the local community. The attraction of academic visitors will have a flow-on effect for local businesses by virtue of increased expenditure and publicly accessible educational activities such as open lectures, seminars, and community education courses being held at Hakitakura. As Hakitakura has been developed, we have sought to undertake consultation and strengthen our relationship with the 7 Papapatipu Rinanga of Ngā Tahu Whanui. They are mana whanua with respect to and hold kaitiangatanga over the site. The university has undertaken this consultation through Okaka for the Otago Rinanga and Te Marama Incorporated Tani, in short, for the Southland Rinanga. This consultation has resulted in the following directives, which have been a key part of the design process. Okaha prepared a cultural value statement, which we have acknowledged this morning, in relation to the proposal, emphasising the need for design outcomes and physical works to mitigate any adverse effects, and management controls in the construction environment management plan to ensure any accidental discovery of relevance to the Rinanga is sensitively and properly managed. The university has consulted with Okaka and Tami in regards to the subsequent stages of the Hakitakura design and development and will continue to do so. Overall, Hakitakura will be a world-class facility that will be available for use by Otago academics, students and staff and the local community. The university is excited by the potential that Hakitakura poses as a way of fostering innovative research as well as a more active relationship with the Queenstown Lakes District and its communities. Thank you.
Thank you. I don't have any further questions. Thank you.
Thank you. I just have 2 hopefully brief questions. At your paragraph 16, you talked about the deed of gifting and outlined the intended use of the land. And I wondered if there are any conditions in the deed as to the operations of the activities or any other restrictions in that deed as to how the land can be used.
Joshua, do you have a copy of the deed in front of you?
I don't have a copy in front of me. I can provide some context if you'd like me to.
I can as well, so I'll let you go first.
Yeah, so the, and I can expand on this in closings. There are controls and aspirations from the Jardines in relation to the land contained within the deed. They're certainly not of the detail. We're talking here about consent conditions. It's more about the vision of what the land's to be used for. It's that level of intent. Nothing particularly specific about what things might look like or all that kind of.
Yeah.
I was wondering if, oh, sorry.
I was just going to add to that, say that the visions of the Jardines has always been to have a facility that is available for the university and the community, which will be available for research and academic activities.
Thank you. What I did wonder was whether there was any conditions over, in your evidence you've mentioned a potential split of 20 weddings and 11 university events, and given the aspiration for the use for the academic purposes in the university, whether the deed specified any restrictions in private use or anything like that? No.
I'm not aware of the deed restricting any use. First call and priority will always be university activities. It will just be if there is availability for the facility to be used for private. But the first call will always be on university activities.
And Ms. Murray, perhaps to ask a leading question, that's not dissimilar to what happens at the university's Otago campus currently, correct?
Correct.
Thank you for clarifying that. That is all I had. So we may move to the next witness. Thank you.
Thank you, Commissioners. Thank you, Ms. Murray. So we'll now move to some of the more nitty-gritty points before we pull back again. So we'll call Mr. Kelly, Traffic Engineer. Mr. Kelly's prepared a summary statement and we'll take any questions after he's presented it.
Good morning, Commissioners.
Good morning. Good morning.
I just have a fairly short statement, which is really a reflection that transportation matters are not amongst the outstanding issues as identified in the legal submissions. My name is Tim Kelly. I'm the owner and director of Tim Kelly Transportation Planning Limited, based in Nelson. You may wish to take paragraphs 2 to 4 as read, just my qualifications and experience. The key points, paragraph 5. The key transportation related aspects of the proposals are: the site is located to the south of the Jacks Point residential area and approximately 11 kilometres from the Franklin commercial area, with vehicular access by means of State Highway 6, Maori Jack Road and Homestead Bay Road. Have you got my evidence there?
Yes, thank you.
B, the location and nature of the proposal means that there will be significant use of group transport, and by that I mean minivans, shared vehicles, etc., resulting in overall low levels of vehicular activity and parking demand. And by low, I mean less than 100 vehicle movements per day, where a movement is an arrival or a departure. Immediate access from Homestead Bay Road will be by means of an existing single lane road, which is Woolshed Road, with the addition of passing bays to be installed as part of the proposal. And 22 formed parking spaces will be provided for staff, visitors and minivans, with provision able to be made for a further 12 spaces if required. I should also add that there will be provision for cycle parking too. The potential effects associated with the operation of the proposal and their associated mitigation are: firstly, the adequacy of on-site parking. The ability to provide further parking only if needed is, I believe, a pragmatic response which appropriately mitigates the risk of an imbalance between parking supply and demand. Secondly, tour coaches. The possibility of larger tour coaches being unable to maneuver within the site is precluded by their prohibition from the site. Thirdly, Woolshed Road, ceiling, width and passing bays. The passing opportunities will be provided, which will be both safe and efficient, whilst preserving the more rural feel of the access environment. And finally, Homestead Bay Road and Woolshed, there's a small typo there, it should say Woolshed Road, not Woolshed Bay, intersection. A widening of Woolshed Road at this intersection and provision of sight lines appropriate for the speed environment will ensure the safe and efficient operation of this intersection. These mitigation measures will be achieved through a comprehensive set of conditions, including a requirement for a transportation management plan under condition 10, which will define how travel to and from the site and the associated parking demands are to be managed. This document requires the approval of council prior to the operation of the proposal. None of the submissions raised any transportation related matters. The only issue of significance raised in the section 42A report relates to sight lines to the south at the Homestead Bay Road intersection, and this was addressed by the request for further information response in July 2021. In summary, standard 29.5.17 of the PDP is not applicable, and it is my view that the sight lines are appropriate in the context of the relevant traffic environment. For these reasons, I am confident that the operation of the proposal will not give rise to any adverse effects which are more than minor. And on the basis of the transportation matters which I have addressed, I consider that consent should be granted for the proposal. Happy to answer any questions.
Thank you, Commissioner.
Thanks, Mr. Kelly. I just had a couple of questions. From what I understand, the first one's just a clarification. Has the site distance issue been resolved between you and Council's traffic engineer?
Yes, I believe it has. I discussed it with Mike Pridham from Council, and my understanding is that he was satisfied with the explanation. Essentially, just to clarify, the standard in the PDP, I only say it's not applicable in the sense that that includes a table for the required minimum sight distances for different posted speed limit environments with a minimum of 50 kilometres an hour. The speed limit on Homestead Bay Road is 40 kilometres an hour, so it's obviously not in that table. And what I've done is really calculate it from first principles, and I'm more than happy that the sight distance is sufficient for that speed environment. And I believe Mr. Pridham agrees.
Thank you. The second question I had was, do you know, you referred to the cycle parking area. Do you know if there is a cycleway proposed between Jacks Point and Frankton at any stage?
I believe from involvement in other projects that there is a proposal, but I'm not familiar with it, to be honest. I guess Council would be better positioned to answer that and what stage it's at and so forth.
Right, okay, thank you. And the third question I just had is on the traffic management or transportation management plan, which will obviously set out how travel to and from the site is going to be managed. Is there anything in your recommendations, and it's maybe for Ms. Taylor to address as well, that has the ability for Council, if this gets given approval, to go back and review that plan to make sure it's achieving what it's supposed to achieve?
I believe so. My understanding is it is a living document. It's not a one-off document that we just produce once before the proposal starts operation. It is something that will be reviewed, particularly in relation to the parking provided on the site. So yes, I mean, I think conditions should be reviewed in terms of parking, signage, use of the entry driveway and so forth. But that's certainly the intent. Perhaps Josh might want to clarify in terms of what the conditions actually require.
Okay, but that's something you would support anyway,
yeah.
like a review there. Okay, thank you.
Yeah.
That was all I had from Mr. Kelly. Thank you.
Thank you. I'd just like to revisit the question about the Homestead Bay Road, the 40-kilometre-an-hour environment. That's helpful to understand. Has your assessment taken into account, as has the landscape assessment, the changing environment and the anticipated environment that will become busier and busier as the boat ramp and other areas develop? And are you still satisfied that the sightlines are appropriate once that environment changes?
Yes, I'm aware there's going to be obviously a significant increase in traffic on that approach. The way I've looked at it is in terms of any vehicle approaching from the south towards this intersection on Homestead Bay Road, would they have sufficient time to react and then stop if somebody happened to pull out of Woolshed Road at that precise moment? And the answer is yes, for any reasonable approach speed, given the speed limit is 40 kilometres an hour.
Thank you, that's helpful. I don't have anything further, so thank you for clarifying those matters.
Okay, thanks.
Just a couple of additions from me, if I may, Commissioner, to clarify or to add to a couple of questions that you've asked. One, and I was just trying to find a particular rule, but there's a rule in the PDP that will limit, which puts a cap on the use of Murray Jack Road for future development in this area. And after that time, there'll need to be a secondary access provided up to the state highway. I can provide some more detail on that in my closing submissions if it would assist, but in a planning from a planning perspective, that will put a limitation on the use of Murray Jack Road in the future. So just a point of clarification there. And the other point is just on the cycleway, just to confirm, I agree with Mr. Kelly's response that the council has approved an active transport strategy that includes a cycleway to this area from Frankton, and that has funding. My understanding is that there's still negotiations with landowners to unlock that, but from the council's perspective, it's approved and has funding.
Thank you, that's helpful.
Look, I will now call Mr. Trevathan, who's also on Zoom. I see he's popped up. Mr. Trevathan will present his summary and take questions. Thanks very much.
Morning.
Morning.
Yeah, so just, excuse me, briefly working through my summary statement. My name is Jeremy William Trevathan. I'm the Principal Acoustic Engineer and Managing Director of Acoustic Engineering Services. And then perhaps skipping to paragraph 5, the relevant noise standards for noise generated by the activity and received at any point within another site are as follows. In the daytime, which is 8 AM to 8 PM, 50 dB LAEQ, 15 minutes, which you can, from a practical point of view, think of as an average noise level over a 15-minute period. And nighttime, which is 8 PM through to 8 AM the next day, 40 dB LAEQ, 15 minutes. And then paragraph 6 just explained the basics of the proposal, which you've heard about already this morning. And paragraph 7 outlined the relevant noise-related conditions of consent. So perhaps reading again at paragraph 8. Worst case noise scenario was modelled, which included the cumulative noise emission from music, people and mechanical plant noise during functions. This modelling indicates that even during larger functions, predicted noise levels are expected to comply with the PDP nighttime noise limit of 40 dB LAEQ. Other more intermittent sources of noise, such as that generated during waste collection and by the backup electrical generator, are also expected to comply with the PDP limits. Noise from traffic using the accessway may at times exceed the noise limits, primarily because the limits require an assessment of noise at the adjacent site boundaries, which in this case are very close to the access road. However, noise at the dwellings themselves will be low. Given these noise levels are only expected to occur occasionally and for a limited period, and are still lower than guideline levels relating to sleep disturbance, I expect any nighttime noise effect to be minimal. Paragraph 10. There is a high level of technical agreement between myself and the acoustic peer reviewer, Mr. Exeter. The only two matters where our opinions appear to differ slightly are Mr. Exeter discusses the possible need for a 3-day gap between events. However, in this case, the number of events proposed is low, the noise levels they will generate is low, and there will be considerable periods of respite, so I do not consider any further controls are required. And then in B, Mr. Exeter recommends a noise limit condition, which also places limits on noise from vehicles using the access road. My noise level predictions are conservative, and noise levels will be at or below the predicted levels at the existing dwellings, regardless of the presence of a noise limit. For a hypothetical situation where new dwellings were constructed very close to the accessway, the condition may not be complied with, and or it would be difficult to enforce, and it's likely that noise effects would be minimal regardless. Therefore, I do not consider that aspect of the noise limit condition to be necessary. Overall, I expect the noise effects of the proposal to be minimal and consider the noise-related conditions attached to the evidence of Ms. Taylor to be appropriate. Happy to answer questions.
Thank you.
Thank you. I just had the one question was about the 3-day gap. and the proposed condition and how it works. I think they starts on a Saturday and ends on a Friday. Does that allow one event per week, or does it allow effectively event to be on a Friday and on a Saturday? And I just wanted to understand. It's an unusual split in the week, and I just wanted to understand what was proposed there.
Yeah, no, it was something that, again, when I was waiting there, I drew out a little diagram myself to try to figure out what it means.
I still couldn't quite work it out.
Yeah, because so what it does mean is that, yes, there could be an event on a Friday and on the following Saturday. But for that to happen, there would have need to have been 6 days with no events beforehand, and then 6 days of no events afterwards.
And Mr. Exeter's 3-day gap between, how would that fit into this proposed timeframe?
Yeah, I'm not clear on that. It's, I guess, a concept he mentions. He didn't go as far as to flesh that out in terms of a possible condition. So I'm, not sure.
Is your understanding of that 3-day gap only apply to these larger functions?
Yes, that was my understanding.
And the only question I had was, you refer to the Jardines new residential unit, and that I think you referred to if their windows are open or windows are closed. I just wondered if you had any information on the layout of their home. Are their bedrooms facing the road?
Yeah,
I'm just conscious that at midnight, most normal, probably asleep, and I'm just wondering on a summer's night, if their windows are open, would they achieve the noise limit, sleep disturbance sort of guidelines that you've been talking about?
So in terms of the first question, no, I don't have any information on the internal layout of those dwellings. The point I was making in the evidence is that even in that worst case scenario where there are bedrooms facing the road and the windows are open for ventilation, then the external noise level we expect is low enough that the noise break-in wouldn't wake you up effectively.
Thank you.
Thank you. I was interested in the backup generator. I did sort of, it popped up, I think, in Ms. Taylor's evidence, and I wondered where the location was. I was just trying to clarify where it is, but your advice is that it would comply with the limits, I see, but I was interested in where it's going to be.
Yes, so because of the separation distances involved, it can readily comply. In terms of someone who's best placed to point out the figure in the bundle, which would show its location the easiest.
Page 19 of the bundle, there's the site plan.
I think it's.
My understanding is it's where the words bike parking and plant room.
It's going to be attached in that.
Broadly attached to that area. And behind the lecture theatre wing.
Yeah.
Is that right?
That's correct.
Yeah, I'm getting nods.
Sorry, where was it, Mr. Leakey? Just behind the lecture theatre somewhere?
Yeah, so on page 19 of the bundle, behind the lecture theatre, there's some car parks, and then adjacent to that, there's some words bike parking and plant room.
So it's the plant room.
So it's the plant room. Yeah.
Okay, plant room.
Right, so it's an enclosed generator, it's not freestanding outside, is that correct?
It would be.
Just outside, was it?
It would be unclear. We were proposing to be on the western side of the bike sheet under an overhang. So it's actually facing away from the Jardines residence. And it's actually quite a long way from the Jardines residence as well. So
Hopefully the commissioners can hear Mr. Ritchie's, but we can perhaps put some questions to him on that if that assisted.
Thank you. And this is just more of a general question from Mr. Tregatham, that this is an unusual one on me to have access, internal site access breach the noise standards. And I was wondering, in your experience, if you've had any other applications where this has happened with vehicles simply coming and going from the site, breaching the noise standards, because often access to sites do follow site boundaries, and I would have thought it was perhaps a more common occurrence.
Yeah, it is, I guess, unusual in that the main access way is not a road, so the noise limits apply. Reasons, there's a mixture. There are similar situations which do pop up. Sometimes if we're talking function venues, that if they're in a rural area, the rural noise limits will apply at the notional boundary of dwellings, and so unless you have a dwelling that's very close to the access, you don't have this type of issue. But yeah, no, it's reasonably common to have activities that, for whatever reason, have a sort of long winding access way to them that either passes close to someone else's boundary or to a dwelling.
And my last question was just simply confirming that, in your view, I take the point that Ms. Taylor and yourself have concerns about the workability of a condition because it's not known where future residential buildings could go. But based on what is there currently, your view is that, as you said in your statement, that it's not going to be a high level of annoyance or disturbance to any of the existing residential properties.
Yeah, that's right. In terms of that nighttime traffic noise, I guess the key points are that the expected levels at the dwellings are low, and they're low in the context of, even if this noise was happening all night, every night, I would be saying the same thing. But then you kind of add over that that will only occur on limited occasions per year. So yeah, it's comfortable in terms of noise effects.
Right. And in terms of that condition that was proposed by Mr. Exeter, have you ever had any experience with that kind of condition where it was unknown that there could be more development? Have you seen that type of condition before, or seen a way to make such a condition work?
Maybe not directly equivalent situation, but again, often in rural areas where the noise limits apply at notional boundaries, there's a discussion about whether the intention is that the condition applies at the notional boundaries of existing dwellings, or should be worded in such a way that it's black and white as to whether it's dwellings that existed at that point, or what would happen if future dwellings were constructed. So perhaps that's the most similar situation, and then it kind of goes to a planner lawyer type discussion about who has precedence, I suppose, and what could be done as of right in the receiving environment.
Thank you. That straying into planning territory, but thank you. That's clear. I don't have any further questions. Thank you.
Thank you. Thank you, Mr. Burton. So we're now back into the room here, moving to Mr. Ritchie. So I might get you to just come up here, Pete. Mr. Ritchie, like I said, a summary, and is likely, I suspect, to refer to the bundle. So commissioners have that handy. I'll pass to Mr. Ritchie.
Thank you. Good morning, commissioners. My full name is Peter Robert Ritchie. I'm a director of Kerr Ritchie Architects. In this statement, I will provide a summary of the key points. The development site is a south-facing and nestled between Lake Wakatipu and the steeper slopes rising to the north. It also has been described reasonably comprehensively by previous submitters. The site currently contains 2 existing dwellings, being an existing farm homestead site comprising of a residential conversion of a historic woolshed, a shearer's quarters, and various outbuildings, all contained within large and established gardens. This proposal includes the conversion of the existing woolshed building, construction of a new lecture theatre, the Hakitakura building and link, and the development of new build self-contained accommodation units, including a manager's house on the lakeside, east of the woolshed. 2 sheds are proposed to accommodate a bus and bikes. The existing shearers' quarters is to be demolished. The woolshed building has a rich and historic character that has been carefully preserved and enhanced by the Jardine family. Our approach has been a light touch to this building's refurbishment. Some upgrades include safety from fire, a structural review, an upgraded kitchen refit, bathroom facilities, and accessibility. We see these upgrades as generally compliance-based, that is not removing the extraordinary existing character of the building. Only minor alterations are proposed to the exterior of the building. The intention is to accommodate parties of up to 60 people within the main former woolshed building for informal gatherings and social breakout space. The adjacent purpose-built Hakitakura lecture theatre will accommodate formal lectures, seminars, and other academic-focused functions. This lecture theatre is to be constructed adjacent to the woolshed with a covered or enclosed link between the 2 buildings. Possibly I could refer you to page 5, which shows the western side of the existing woolshed with the link which is attached to the existing building, which takes you through to the new lecture theatre.
We haven't seen these before. Are these new renders?
No, these are from the application. We've just pulled them into the bundle just for ease of reference. So it's not new material. I'll just check with Ms. Taylor. It was the original application they were.
Yeah, so these visuals were in the appendix 2 of the application.
Thank you.
Just to clarify, the architectural drawings that follow later were in the RFI because they updated the previous set of drawings that were in the application.
Okay.
So paragraph 10, sheltered external breakout spaces are provided adjacent to the building with a proposed new outdoor courtyard space adjacent to the west side of the Hakitakura building. This will be set amongst and into the existing garden area with mature trees and some new stone walls and possible glass screens for wind protection. I think that image on page 6 outlines that description. The building is largely contained within an established garden and will effectively be placed close to the location of the existing shearers' quarters. The form of the building has been generated by the immediate landscape surrounding, essentially a wedge form with a steeper pitch tilting up to the landform behind. The exterior materiality of the building is largely charred Otago timber, weatherboards, and locally sourced schist. The charred timber, which is black, will recede into the existing garden. Our western courtyard, being an external breakout space, will be contained by the garden and steep rock bluffs. I think you can see on page 7 there, it's taken from the top of the rock bluffs. So essentially the rock bluffs, they really form the western fringe of that breakout space between the new Hakitakura building and the bluffs themselves. The accommodation components to the east of the woolshed will take the form of clustered groups of buildings to form a series of communal courtyards. Rural building forms can both be sculptural extensions of the landscape and a response to existing built heritage. The architecture seeks to be a subtle insertion into the landscape, drawing upon the clues provided by the site. They will integrate with the physical and architectural landscape of the site. The gabled forms are reminiscent of the existing shed forms found on the site, be it the woolshed, kennels, covered yards, glass houses, and garden sheds. Each accommodation unit will have a high level of privacy, while also maximising sunlight and there's particular views to Lake Okatipu and the nearby remarkable mountains. The buildings use a simple material palette of corrugated steel, timber weatherboards, concrete and stone. All of the chosen materials and colours complement the rural landscape and are generally in keeping with the design, materiality and language that's found in the adjoining Jacks Point development. And if you, on page 9, there's actually a little montage as well of the gabled form buildings. Essentially, there's five groups of buildings with 16 accommodation units. The proposed landscape planting largely respects the existing gardens and vegetation. Most new planting will occur around the accommodation units to the east of the site. It will largely comprise of groupings of native beech, kofi, and mixed native groupings. These plantings will soften and screen the buildings and integrate into the existing grounds. The existing archaeological features present on site have been integrated into the proposal. This includes parts of the historic fabric of the woolshed building. The building was extensively remodelled in 2007, with parts including sheep grating, reuse of timber walls and timber shingles, particularly in the entry, were incorporated into the design and will remain as part of the proposal. The gardens, galvanised iron bathhouse, remains of the timber wharf structure, together with the historic trolley and the stone fireplace identified by the site archaeologists, will remain. We reinforce that a light design touch has been afforded to the existing site features and buildings, as these provide genuine character and history. In response to the Section 42A report, it is proposed that the timber board cladding of the staff and accommodation unit buildings will be stained to a black colour, Bodo, Vulcan, ebony, thereby reducing light reflectance and potential visual prominence. So essentially that's the image on page 9 again, the natural timber faces you can see there, and also turning over the page, you can see equally there's some timber facades which will be stained dark as opposed to left natural. To conclude, it's my opinion that the proposal represents a unique solution to rejuvenate a part of New Zealand's farming history into an innovative educational facility that is sympathetic both to the site's history and the wide landscape context. Thank you.
Thank you. I don't actually have any questions, but I'll check with.
I just have a couple, Mr. Ritchie. I'm a little bit confused. From the best of my knowledge, I can't find those renders in our bundle of documents. And were they attached to your plan set? I've got your plans being your set of plans repeated a couple of times in the application, but I have not seen these renders before, and they're very useful. Thank you. The other couple of questions I had were based on Mr. Denny raised an issue that some of the design elements were missing. Has that issue been addressed and resolved?
I think that most. I think most design elements have been resolved. I mean, we've annotated, the buildings, they're all been elevated and materiality's all been shown, the landscape plan's been shown. I think there's very little left to left to the imagination. But I'm certainly happy to answer any specific details if there's any outstanding issues.
No, that's fine. I just wanted to see where that issue was at. The other issue of this building with its extraordinary history, was there ever any heritage protection on the building, or is there anything proposed in any of the submissions on the PDP?
I can take that one if that's all right, Commissioner. And it's a point I've been exploring this week because it's been on my mind. The fact that there's not. So I've looked into that and confirmed, and yeah, despite the site's sort of long history, it's not listed for heritage protection in the district plan, and it's not listed by the Heritage New Zealand, and Dick's confirmed that. So the heritage control would be that archaeological authority trigger due to the age only. Yeah.
And the only other question I have for you, Mr. Ritchie, was there any, just on the proposed height of the visitor accommodation block, did you ever explore a lower height, or just looking for some justifications on the height that is proposed?
Well, I think we wanted the, we were quite keen to employ a gabled form, which is, you know, a traditional building form extending from the other buildings on the site. Equally, we also wanted the interior of the spaces to be interesting as well, you know, and so we, you know, to reach up and to capture the sun via some skylights. So, you know, I think we certainly have worked through, you know, a great range of options over the, you know, 5 years which we have been working on the project, and there certainly have been options of different forms proposed, but you know, together with the university, we settled on this as being an appropriate form, and you know, I think that, you know, if you look at I suppose you look at the existing buildings, they're certainly no higher than the existing buildings on the site, being shearers' quarters and the existing wool shed. So I think they reach up to about 6.5 metres high. I think they are appropriate for the site.
Thank you. That was all I had, Mr. Ritchie. Thank you.
Yeah.
Thank you, Mr. Ritchie.
Yes.
Moving now to Mr. Espy, who I'll get to shuffle chairs a bit. So Mr. Espy's landscape plans referred to them already, so I should remember. Tab page 31 of the bundle. Mr. Espy's prepared a summary statement as well, which he'll present, and take the commissioners through the landscape plan.
Thank you, commissioners. I'll go through my summary and then I'll talk briefly to the plans. I'll skip my introduction there, the first 4 points, and I'll move to number 5. So in relation to the proposal, I supervised and reviewed the landscape and visual effects assessment report that was part of the application. I agree with and adopt the findings of that report. I also prepared a memo November 2020 regarding landscape issues in response to an RFI. And that memo in response to the RFI included an updated proposed structural landscape plan and an inventory of existing mitigated vegetation to be retained and a schedule of the proposed vegetation. Under the decisions version PDP zoning, the vicinity within which the site sits will change considerably from what can be seen on the ground today. In relation to what the decisions version provisions provide for, the proposed activity will sit within a rural living enclave that is adjacent to a dense village and marina development. Pursuant to these provisions, residential units can be placed in the location of the currently proposed buildings. Additionally, given the vision of the QLDC spatial plan, it appears likely that the final zoning of the Homestead Bay area may involve significant further upzoning to create urban or suburban densities. The potential landscape and visual effects of the current proposal need to be assessed in relation to the environment that anticipates significant development of Homestead Bay. The adverse effects of the proposal on landscape character will be of a low degree, particularly as the Homestead Bay area is developed and the rural character is replaced with a relatively built-up mixed-use character. Additionally, the natural and rural character of the upper reaches of Jacks Point Hill will be retained, and the ONL part of the subject site will remain in its current state. Structures will be concentrated in the lower, less conspicuous areas of the site where existing development is already located, and the proposed architecture ties in with existing buildings. The design ensures the facility fits comfortably into the existing rural landscape, as well as the future mixed-use development anticipated in Homestead Bay. The adverse visual effects of the proposal will also be of a low degree. The facility will sit in a discrete location at the base of Jacks Point Hill, and as discussed above, proposed structures have been designed to be sympathetic to their setting, both in its current form and as it will become pursuant to the PDP provisions. The proposed facility will be of a significantly smaller scale than the village centre and marina areas that are provided for. In views from the south, the lake and its margin, the activities will not appear out of place in this setting. Mr. Denny's peer review regarding landscape and visual amenity effects raises some issues regarding the visual effects of the eastern parts of the proposed built form, finding that they are in an open or exposed location. And since the lodgement of the application, more detailed information regarding the proposed landscape treatment has been provided. The location in which these eastern buildings are proposed is already framed by mature vegetation. Openness only begins further to the east, beyond the existing shed, yards and pump house, which is in the OSF activity area. The proposal includes very considerable planting using advanced grades in the area of these eastern buildings in order to enhance their vegetated setting. As is shown on the structural landscape plan, considerable planting has been done on the Lynn's land adjacent to the site that currently provides some visual screening from the south. This vegetation does not impede access along the foreshore in any way, and it's difficult to imagine circumstances in which Lynn's would wish to remove this vegetation. Nonetheless, in the event that the vegetation is removed, it's the intention of proposed condition 14 that a vegetation design is submitted and approved, sorry, that's now 15, submitted and approved that achieves a level of visual mitigation that is appropriate in relation to the PDP provisions that apply to the site. So considered in an overall sense, the proposed buildings and activities sit within a location which has historically been a farm base area and which is enabled to become a rural living enclave adjacent to a dense village and marina development. In this context, any adverse effects on the proposal on landscape character or visual amenity will be of a low degree at most. Now, it might be worth just, while I'm talking, going to that proposed structural landscape plan, which is in tab 3 of the bundle, page 31. So this is the updated version that came in response to an RFI. So the first page there is the plan, 31 is the plan. And on this plan, the existing, if you look over to the key, the bottom item on the key there, existing vegetation providing mitigation located inside the site. So the idea is that vegetation, which is existing and provides a mitigatory function, that's identified on the plan, and then conditions of consent can enforce that. It's worth noting that there's also a great deal of other existing vegetation in and around the buildings that's not proposed to be removed, not proposed to change. But since it doesn't really provide any mitigation function, it's thought best not to link that to some condition of consent, not require that to be identified in a plan. I'm talking about the lower stature vegetation, which is vegetable gardens and amenity gardens in and around the buildings. There's no desire to remove any of that. As Mr. Ritchie has pointed out, the idea of the design is to tie into that interesting and unique context, but the low vegetation is not linked to any consent condition, but the high vegetation is. So that's the idea of the lighter coloured vegetation that's identified in that plan. While we're on existing vegetation, you can see on the plan there's a red dashed line, which is the site boundary, the southern boundary. So obviously moving to the south of that southern boundary, you're into this public land that sits between the site and the lake. And then you can see the lake edge in that plan as well. And marked in a red colour is vegetation on the public land that currently provides a bit of a visual screening function for some of the buildings. And it's quite extensive vegetation, as you can see. If we move over to the next page, page 32, which is a schedule of the vegetation. The first part there is a schedule of existing vegetation, numbers 1 down to 37, which relates to that plan. And then at the bottom is the schedule of new vegetation, proposed vegetation that's going to go in. So that vegetation that's on the public land comprises of a lot of native vegetation, a lot of native beech, and as well as lower native shrub vegetation, mixed vegetation. It's all been obviously deliberately planted. It's in rows and shapes, and it's been maintained. So it's interesting vegetation. It's not, some of it's quite mature, but none of it's overly mature. And as has been pointed out in the evidence, that's on the public land, but nonetheless it's there. And then moving to the proposed vegetation, which on page 31 on the plan is marked in different colours. It's sort of the second half of the key, second half of the items on the key. There's native beech planting. There's 100 or so native beech trees, as well as mixed lower native trees, kofi and cabbage trees and things, and then various sweeps of high native shrubs. And most of that, as you can see, most of that, or practically all of that proposed vegetation is on the eastern half of the site. So that's that structural landscape plan. Happy to answer any questions on that or on the evidence.
Thank you, Mr. Espy. Commissioner Sinclair.
Yeah, I have a couple of questions, Mr. Espy. Just with some of this towards the eastern side of the site, and some of this landscaping that I see is quite a little bit further away from the visitor accommodation blocks. Has there been any thought considered on getting this sort of structural planting planted, if consent was granted, planted before those blocks, that block is built, given that it could be 9 years before that block is built, that planting could be established? Have you thought about that, and would you support that approach?
As I understand it, the current conditions require, given that things might happen in stages, the current conditions require planting to be done immediately following the building of the buildings. So if those eastern buildings are built later, the planting has to come immediately after that. I suppose there's nothing to stop planting being done earlier than the buildings, provided that planting that's particularly close to the buildings and is going to get damaged during the building process isn't planted. So you could almost divvy that eastern planting into two categories. Structural type planting that forms a frame that is further away from the buildings, and then planting that is particularly close to the buildings. And the former type of planting could be done prior to the buildings. Yes, it could.
Mr. Espy, was there any, I see it's just on the foreshore ONL boundary line, did you have any response to Mr. Denny's position of that boundary line? Was that an issue of dispute?
I don't understand it to be an issue of dispute, no. As I understand it, the appeal that we heard about in relation to the O&L line that was settled via mediation, I was part of that mediation, and that was to do with the O&L line at the foot of Jacks Point Hill to the north of our buildings. And that was settled via mediation and is now in the PDP. So the line that's in the PDP is the fixed and final line. And that also applies as well. There was no appeal in relation to the O&L line in the foreshore area. So as I understand it, the O&L line in the PDP for that foreshore area line is also the final line. There's no dispute about it.
In your considerations or in your assessment, we talk a lot about this anticipated environment, and if things go ahead as planned through the PDP, did you consider that area along the foreshore would be a lot more public access, maybe through the marina? There'd be a lot more boating activity out on the lake and perhaps people walking along the foreshore towards the university. Did that factor into your consideration, and what was your response?
Yes, it did, and I think I set that out in either in the landscape assessment report or in my evidence. I certainly anticipate by the time the Homestead Bay zone is developed, it doesn't even need to be fully developed. You know, once it's partially developed and there's a village and there's a marina and there's a lot of residential land use, some of it very dense. Yeah, I imagine that foreshore area, which is quite a large, wide strip of public land. It's not just the beach, it's quite a large area of public land along that whole foreshore of Homestead Bay zoning. I anticipate that will change, and I think I say in the evidence it may well end up something like the Frankton Beach Foreshore Reserve. It might end up quite a parkland. So I would anticipate that things like existing areas of native tall beech trees and things would be retained as part of that, and the parkland is surely to include some very open grassed areas and some treed areas as well. So yes, I think that's a consideration.
And just the last question I had was relating to just proposed landscaping around the accommodation block. And maybe if you could talk to the plan on this, just so I'm clear of what is proposed. It seems to be quite strategically placed, obviously, in order to gain views out onto the lake, but there doesn't seem to be a lot of planting proposed in that area. And I'm just wondering, what's your response to that? And also, it might be a question for Mr. Leakey, is it something that that we can consider, or have the applicant considered some planting on the Crown land and what that process would look like?
Well, I'm looking at the structural landscape plan that we've been talking about. I'm also looking at an appendix to my evidence.
Yeah, I'm looking at page 31. Is that what you are, Mr. Espy?
Yes, page 31 of the bundle.
And on the back of 32.
That's right, and in the back of 32, okay. I'm also actually looking at appendix 3 to my evidence, my brief of evidence, which is a photograph. Might be worth looking at that if you've got that in your bundle somewhere.
So is that the first photograph? Yeah. Oh, the 21. Sorry. Yeah, I have it.
So appendix from my brief of evidence, appendix 2 is an aerial photograph, and then appendix 3 is a photograph from the lake.
Yeah.
Yeah. So, well, if we look first of all at appendix 2, which is a fairly recent aerial photograph with the outlines of the buildings on it, we can see those eastern buildings, and behind those eastern buildings, there's quite a bit of mature trees, eucalyptus and tall willows, sort of framing up that area, that relatively open area that those buildings are sitting in. Then you can see the vegetation that's on the public land as well. And that's shown on the proposed structural landscape plan. If we go back to the proposed structural landscape plan for a minute, behind these buildings, there is the existing willows and eucalyptus and things that are going to be retained, which are numbers 12 and 13 and 37 on that plan. So they're very big mature trees. And then we can see between 11 and 12 and our proposed building, there's a number of native beech trees. And then over to the east of number 37, there's another big sweep of beech trees. There's 100 beech trees in total in that eastern area. So obviously they sit to the north and to the east of our buildings and form a backdrop to it. And if we look at my appendix 3, which is the photograph, we can see the view that people would have. And of course, it's relevant that the topography rises up as you move away from the lake up towards Jacks Point Hill. The land is always rising up. And so these trees behind the buildings will be very high prominent trees behind the buildings, including the native beech trees that get planted. They'll end up being a really treed backdrop to those buildings. Now, as far as the front facade of those buildings, you're right in the tree planting that's proposed in front of those buildings, close to the front facade, has been located between windows and in areas where views out aren't required. And that takes the form of, looking at page 31 of the bundle, that takes the form of clumps of cabbage trees along that front facade. And then on the public land, where it's got number 35 and number 36, those are long lines of native beech. So they will certainly filter the buildings quite a bit, but the intention of the proposed planting is to frame views out from the buildings, but not block views, obviously, to or from the buildings.
Mr. Espy, just on your landscape plan, it seems to be one long continuous building. Have you done that just for, because when I understand, I saw it was 2 buildings. Have you just done that as one block, just for illustrative purposes?
Yeah, you're correct. It's drawn as one block there, which is probably not very helpful. If you look at my appendix 2 and appendix 3 of my evidence that we've been looking at, it's shown as 2 blocks, which is
Okay.
better.
I just had one other question. Just to the western side, to the lecture theatre and the dense vegetation that is in that area, and that the building's been designed with a glass facade looking out to the lake, and the temptation of people to slowly trim trees to get better views. How do we ensure that that planting is retained as it's supposed to retain, and what tools have we got to make sure that that doesn't occur, that things are slowly sort of pruned?
Yeah, Mr. Ritchie has just suggested that the wind's quite a good incentive to keep those trees there. It does get a very strong southerly wind off the lake coming up there, and I'm sure that's a big part of the reason that those trees are there.
Okay.
But as I understand it, the facades of those big buildings have been designed to have framed views through trees to the lake and to the mountains. As we've said, or as has been pointed out in the evidence of other witnesses, the vegetation that's not on our land, the vegetation that's on the public land, we have no control over, and so it's sort of out of our hands a little bit, but the intention is certainly that the buildings don't require that vegetation to be removed at all.
Just from a just from a legal perspective, to respond to that, I mean it's Crown land managed by LINZ, and in my submission that's the reliance that we can really place on the retention of those trees. If they were removed, it would be if they're removed by the university, it would be a trespass criminal legal matter. The only other option would be some kind of license to occupy or lease arrangement that hasn't been explored with the Crown. And I understand that we do see that more regularly with QLDC reserves, where mitigation's relied on, and QLDC does sometimes grant licenses to occupy to ensure protection of trees on council land, but less common with Crown land. But yeah, the control really that we rely on here is the fact that it is Crown land managed by Linds.
No, I do go back, I guess, to that point before that Commissioner Sinclair was getting at, is that if we step back a bit and look at the big picture, it may well be that this reserve becomes quite a different reserve that's quite well used and quite populated, and that people walking along this reserve from one end to the other will walk past a marina, they'll walk past a dense village that touches on the reserve, they'll walk past large areas of fairly dense suburban living. And if they walk down to the end and they see a cluster of university buildings, I don't think that's adverse. I don't think that's detrimental to their amenity. I think it's probably quite positive. So I don't take the stance that the buildings need to be hidden.
That was all I had, Mr. Espy. Thank you.
Thank you.
Thank you, Mr. Espy. I was just wanting to explore with you a bit more detail around the landscape plan, and in your evidence you refer to planting advanced grade trees, and I see you've specified the beeches that will be 2 metres in size. So my question is there any, what are the pros and cons or advantages, disadvantages of planting larger grade trees in terms of growth rates as opposed to smaller ones? Do they suffer shock when you put in a large one and then slow up for many years, or is it much of a muchness? Is there a difference there?
Well, the grades that we're talking about, yeah, is 2 metres for the mountain beech and then 1 metre for the others. It's pretty large grades given the number of trees. The advantage is the short-term effect. There's no real long-term advantage. If you plant a 2 metre beech tree beside a 1 metre beech tree, in 15 years' time, they'll both be the same height. So it's a short-term gain to deal with short-term effects, but it's not really a long-term gain.
Thank you. Then in terms of the 100, I was quite interested that it'll be a little forest. I mean, do you say that there'll be any filtered views as viewed from the east, or will it completely close in and it would only be visible from the foreshore in time?
Yeah, I think from the east and from the north, these buildings will be pretty closed in, and the access driveway that comes along and comes past the Jardines house, that access driveway is higher in elevation. It's up the hill from our buildings, and so the trees between that access driveway and our buildings will more or less screen the buildings. So it'll be very treed driving into the site, and over to the east of our site, if somebody is on that OSF public land to the east of our site, these buildings will be quite enclosed. Yeah, that's right. That's the intention, to create quite a backdrop to them.
So just to be crystal clear, you expect in time someone to the east would perhaps not be able to view the buildings if they were due east? The tree will be higher than 6.5 metres.
Well, yeah, that's probably right, depending on exactly where you are. There will be filtered views through trees, I'm sure, and there'll be some gaps. It's not a complete wall, but it'll be quite largely screened.
So in terms of the core 5 proposed, are these semi-deciduous trees, is that correct? So they're more of an amenity planting, or am I wrong there?
They are semi-deciduous in that they don't completely lose their leaves over winter. So they're quite quite a visual filter, really, summer or winter. They're not huge trees, of course, but they're quite a strong visual filter, but they're not a real blockage. That's right.
And I noted that Mr. Denny pointed out some of the assessment criteria talking about food for birds and insects, so that would be meeting that criteria.
Yeah, that's right. Certainly the kowhai and the southern rata, and also a lot of the shrub species.
Thank you. Sorry, I'll just check here. Again, this is probably a question for the planners, but the discussion earlier about it being unlikely that vegetation would be removed from the limbs land, would that need a consent? Do you know, or should I save that question for the planners?
Yes, I don't know.
Okay, thank you. And one of the things in Ms. Baker's section 42 was her reliance on Mr. Denny's advice and peer review that the effects would be moderate to high. And in her report, she has equated that with a significant effect from a planning RMA sense. And I was wanting your guidance on, when you work with planners and prepare your evidence, how do you translate your landscape guidelines continuum of effects in a planning sense? So Mr. Denny set out that if it's, I think it was low to moderate, it's minor, and then as it progresses, at what point does it advance in a planning sense from being moderate to significant? Or do you have any comment?
Yeah, I understand the question. There is, since the time our original assessment report was written, the New Zealand Institute of Landscape Architects has finalised a guideline document to do with landscape assessment, and it has finalised, well, part of that document sets out how to relate a hierarchy of effects to minor, more than minor, significant. I'm just trying to find that. It might actually be in Mr. Denny's report, but I don't think there's any disagreement between us about the words and how to relate them to the RMA. The disagreement is just about the degree of effect.
No, but my question is relevant because if Mr. Denny's saying it's moderate to high, and Ms. Baker's translated that as significant, but Mr. Denny hasn't provided the full scale, so he's talked about with a minor, but I haven't found anything in Mr. Denny's evidence saying what a moderate to high impact is on your landscape scale, how that translates. So it is relevant.
Yeah, I'm just looking through Mr. Denny's report to see if I can find it.
Thanks. That's footnote, I think. But on his paragraph 30, he talks about moderate to low being corresponding with minor, but he doesn't go on to tell us what moderate to high corresponds with.
Oh, I see what you're saying.
So I was wondering where Ms. Baker got the significant from.
Yes, I see what you're saying. Yeah, it's his paragraph 30. Yes, I notice he's got a footnote there, his footnote 2. That's the guideline document that I'm talking about. Now, it's definitely in that guideline document. I haven't got it in front of me, but I can come back to you on that.
That would be helpful. I would like, I mean, Mr. Denny may be able to assist later, but I would like to understand what that guideline document says, because I can't find it in any of the evidence.
Okay, certainly.
Thank you. And then the last one again relates to those guidelines, which you've pointed out have since been finalised and weren't final when the original application assessment was prepared. So am I correct that both yourself and Mr. Denny are saying that the appropriate methodology is being used, it's just you've reached different conclusions, so that there's no difference in your methodology? You've both followed those guidelines but reached different conclusions, is that correct?
Yeah, yes, that's correct.
Now, just one last check, I think that might be all of my questions. Commissioner Franklin?
No, I don't have anything further. Thank you.
Thank you, Mr.
Yeah.
Eastwood.
Thank you.
We've got two more witnesses to go. I'm conscious of the time as well. Would now be a good time for the commissioners to break for lunch? Or would you like to hear from Mr. Lloyd and then break?
I would like to break now. Thank you for being such a good timekeeper.
That's all right.
Good time. If that suits everybody, I will take a break for 1 hour and reconvene at 1:30.
It suits us. Thank you.
Thank you, everyone. Good afternoon and welcome back. I hope you all had a refreshing break. We enjoyed our walk around the waterfront. So back in your hands, Mr. Leakey, with your last two witnesses.
Thank you, Commissioner Dimmery. You're very lucky getting a walk. I didn't let our team leave the boardroom.
You're a tough taskmaster. I hope they don't punish you.
They'll be very focused this afternoon because of it. If the commissioners are minded, I'd just like to pass to Mr. Espy initially, who's got some comments on the NZILA guidelines, just to respond to your question, Commissioner Dimmery, on that, and then we will keep moving through the list. So, Mr. Espy, could you just perhaps lead in with a bit of background to that, the guidelines point?
Yeah, sure. So, as is referred to in Mr. Denny's report at paragraph 29, the New Zealand Institute of Landscape Architects has been compiling a guideline document for landscape assessment for some time. And at the time of Mr. Denny's report, he refers to the final draft of that guideline. And that final draft is something that the members of the NZILA use. It's final in terms of its wording. It's only draft because its graphics and publishing has not yet been done. And so he refers to that final draft, and in his paragraph 29 and 30, he talks about how to describe the degree of an effect. And in his paragraph 30, he notes that an effects rating of moderate low or very low corresponds to minor. Effects rating of very low corresponds to less than minor, and an adverse effects rating of moderate and above is more than minor. Now that's correct, and as Commissioner Dimmery pointed out, he doesn't mention what is a significant effect in that paragraph. And I'm looking at the guidelines document here, and I went back and checked it, and the part that's missing perhaps from that commentary is that a high effect or very high effect is described as significant. So a moderate or moderate high effect is described as more than minor, but less than significant.
Thank you, that assists greatly. Thank you, Mr. Espy.
What page, what paragraph, Mr. Espy, in the guidelines?
In the guidelines document, that's paragraph 6.37, if that's of any use to you.
Okay. We'll move now to Mr. Lloyd, who's sitting next to me, who's done a summary statement as well, engineering, and happy to take questions once he's presented that.
Good afternoon, Commissioners. My name is Nigel Richard Lloyd. I'll skip points 1 to 4 of my summary statement, move to the key points, which is my evidence covers a range of topics relating to the feasibility of infrastructure servicing earthworks and liquefaction hazard. The key aspects of the proposal in regards to these engineering matters are: the proposed development will retain and develop upon a number of existing elements of the site and will be staged in response to current infrastructure constraints associated with wastewater servicing. The site is accessed from Homestead Bay Road via the private Woolshed Road, which will be minorly upgraded and sealed to provide access to the site. Necessary car parking and vehicle manoeuvring will be provided utilising the existing site provisions, supplemented by new on-site infrastructure where necessary. The proposed earthworks relate directly to the various elements of the proposed development and as such will also be staged. Based on my assessment and subject to detailed design and best construction practice techniques, the earthworks associated with the proposal are able to be contained within the site. I consider that the earthworks, both in part and as a whole, are appropriate, and any adverse effects will be appropriately managed through the proposed environmental management plan and the conditions that are proposed around that in the consent. The site is generally well suited to on-site stormwater disposal due to the generally well-drained nature of the near surface soils. Stormwater from the development will be managed in a similar way to existing stormwater, with additional control and discharge measures constructed as required. And I guess probably the key thing to note there is when I say it's generally well suited and well drained, I'm referring to the lower lying area of the site where the development is proposed, as opposed to the site as a whole. Water supply to the proposed development will also be staged. The initial stage development will be serviced using the existing on-site bore, along with proposed buried storage tanks, water treatment system, and pressure boosting pumps. Council engineer, Mr. Purdom, agrees that this is a feasible solution. Given the reduced facilities and site usage under the initial stage, I consider that a figure of 3,750 litres per day would be more realistically required for the initial stage. This differs from Mr. Purdom's recommendation. However, I would recommend that this figure be confirmed through the detailed design process. And in any case, I would note that the water source and supply is not a critical constraint, and more water is available if needed. So there's not a high, there's really no sensitivity around what that actual number is in regards to the proposed development and the availability of water. Subsequent stages of the proposal will be serviced by connection to area-wide reticulation once this becomes available. The provision of this is included in the council 10-year plan. Potential geohazard risk, and specifically liquefaction, has been assessed by ENGEO, and this has shown that there is the potential for liquefaction in some areas of the site during a large ultimate limit state seismic event. This will be assessed in more detail for each of the key elements of the project, and if necessary, mitigated through specific engineering design at the detailed design stage of the project. The further detailed assessment, along with any detailed design responses, will be assessed and approved by council through the building consent process, as is typical. I note that no issues have been raised regarding any of the above items by the Section 42A report. Wastewater servicing and infrastructure for the proposed development will be staged. The initial stage of the proposed development will be serviced by internal reticulation and a buried wastewater storage tank that will be emptied as required by an effluent tanker, with wastewater disposed of off-site. My assessment indicates that the initial stage of the proposal will require less than one truck movement per week to remove wastewater from the site. However, I wish to note that this assessment is conservative in nature and makes no allowance for measures to reduce wastewater generation. There are a number of options and elements that will be considered in more detail through detailed design phase, which may further reduce that, but we have been conservative in our assessment to date. The Section 42A report agrees that storage and offsite disposal is an appropriate approach, and the adverse effects are minor and acceptable. Future stages of the proposed development will be serviced by connection to area-wide reticulation by way of a pump station and small diameter rising main once area-wide reticulation becomes available. Provision for area-wide reticulation, which is necessary to support the development as anticipated by the structure plan in this area, is included in the council 10-year plan. I consider this approach as technically feasible, acceptable, and appropriate in light of the proposed conditions of consent relating to this matter. I disagree with the council engineer and the section 42A report and the view that this cannot be considered to be a feasible solution. Based on my assessment, I consider that the proposal is both technically feasible and the potential effects are acceptable from an infrastructure, earthworks and geohazard perspective. The one other thing I'd like to note was just in regards to the query raised earlier about an area of seepage, which I'm assuming is upslope directly to the north of the accommodation blocks. Was that the area that you noted that seepage?
Yeah, yes, it was not too far up slope, but it was on the slope, and I discerned didn't seem to be any outlet pipe or anything, so I just noticed it was significantly more wet.
Yeah, so I guess I can perhaps provide some context to that, as I've got some knowledge of the site and the ground conditions gained through the course of the various assessments and investigations done for this project over the years. And we have noticed seepage in that area at times. It is definitely ephemeral or temporary in nature, in that when I was out on site last week, there was no obvious seepage. We obviously have had a lot of rain and snow since then. My view, based on the subsurface site investigations that we've done, is that area of seepage, which occurs at times in sort of a horizontal band across the site below the road, over a relatively limited extent, that relates to the near surface rock coming closer to the surface, and so water within the near surface soils is getting pushed back to the surface. So I mean, my view is that seepage area is a function of the rock profile coming back to the surface, and essentially any minor localized near surface water having nowhere to go other than coming back to the surface. So hopefully that might provide some sort of context. I don't believe it's indicative of a wider groundwater or, water course or wetland type feature.
Thank you, that's helpful, that explanation. Now, Commissioner Frankie, I believe.
I've just got a couple of questions. The first one is just what background information do you have on the southern corridor for the wastewater treatment? Do you know where it would start and where it would finish, or how long it takes to construct, or are we not at that stage yet?
There's been various studies and options looked at, which I am aware of. I'm not able to confirm where exactly it is in the process at the moment, but it is essentially intended to connect this Jacks Point zone, including the Homestead Bay development area, to project shot over the existing Queenstown wastewater treatment plant that's located on the Shotover River Delta east of Frankton Flats. So where that might, or Mr. Lecky's just giving me
I'm just passing the spatial plan to Mr. Lloyd, and it may provide a reference point in a document that everyone has. What's the page number? Sorry,
96.
96. This is the red line.
Yeah, red line number 6 is the Southern Corridor conveyance scheme. So yeah, nominally it's crosses the Shotover River and goes to, the Kawerau River and goes to the Shotover Delta and the wastewater treatment plant. It nominally, the trunk main runs along State Highway 6 and then enters into the Homestead Bay site, which I assume is by the future State Highway 6 intersection. But I mean, I guess what I'd say about that is that that's the trunk backbone only. There will obviously be a lot of branches and connections made off that as the area is developed as well. But it looks like it's actually originating in this concept, and I would say it's an early concept only in an engineering sense, but it looks to be originating from the vicinity of the marina area.
Sorry, what was the last part from the marina?
Yeah, it looks to me from this concept plan to originate from, the area of the marina.
Right, would it be number 4? Would that be on the map? No?
Sorry, what's that?
There was you're talking about Queenstown Marina?
No, the Homestead Bay.
Oh, Homestead Bay, gotcha.
I'm sorry.
I got it lost me on the marina.
Yeah,
right.
sorry, what is it actually called? Boating facility area.
Yeah, correct.
Boating facility area.
Thanks for clearing that up. And thank you for that map, that's helpful. The only other question I had was just, I'm aware that the application has changed with, previously it was that you were wanting to construct it and then not use it until it was connected. Now it's not construct until the infrastructure has commenced. I'm aware that I was just looking at your last paragraph saying that the council's view is not feasible. I'm wondering, we'll hear from them, but I'm just wondering if you know that they still hold that view. Have you had discussions with them, or we'll hear from them what their most updated response is to your change in application? But does that not feasible stem from the original application as proposed, or has that carried through to your new proposal?
I believe the not feasible stems from the original proposal. And I guess to give some background to the reason for this change is when we started out on this project, the Southern Corridor infrastructure was seemingly more imminent than it was, in that it was sort of slated for 2 to 4 year horizon in 2018. This would have been when our involvement in the project started. And then that just kept creeping, and it was always 2 to 4 years. And then it's, I guess, been, in my view, solidified and pushed out slightly in the 10-year plan. But probably to what I would say is a more realistic time frame. And I note Mr. Leckie made the comment earlier about funding for construction being over 3 years. Again, I would probably say, coming back to your earlier question, a sort of 3 year time frame for construction for a project of that scale would seem realistic. Probably conservative, but probably expecting that there might be some preliminary works in year one, and the main works might happen over, say, 2 summer construction seasons.
Thank you. That was what I had. Thank you. Mr. Lloyd,
When I was reading the section 42A report, Mr. Pridham talks about the effluent disposal, and it's a question I'll clarify with him, but he does talk about the uncertainty, and he mentions, and this is where I'm not clear, a third-party landowner approval to connect to the existing network at Jacks Point Village. So is that what's there currently? And was that an alternative that was considered for this proposal?
Correct. That was one of actually quite a number of alternatives that were considered. And we have, we have assessed alternatives extensively, I would say, because really, the university's preference would have been to bring online more of this development sooner if possible. But yes, that third-party landowner approval reference is in regard to a potential for a connection via Jacks Point into existing council infrastructure in the Jacks Point Village area, which is currently connected, which then currently connects to Project Shotover wastewater treatment plant via the existing State Highway Bridge and Hanley Farms. Yeah.
So with that existing line, is there capacity in there if you were able to secure that third-party consent?
That's a bit of a loaded question in that some of that capacity has been allocated, we believe, to future or third-party future development. So currently, yes, we believe there is capacity. And although some parties would maintain that it is their capacity and not council's. So, I mean, that is probably what I'd put in the category of a peripheral complication. The main constraint to that option is a third-party land approvals to access the council network that we haven't been able to, or we're not able to achieve. Yeah.
Okay, so that follows on nicely to my question that in your experience, and Mr. Leckie might be able to assist here, are there not provisions under the Local Government Act for council to go in and facilitate connections where one is not available and if an approval could not be obtained, and has this option been explored?
Yeah, I can take that.
I've probably got some thoughts, but yeah, I'll let Josh lead this one.
Both for the university, but also for the Jardines, the use of this connection, something that we've been pushing very hard for several years now, very frustratingly, without success. We consider that the council does have power under the Local Government Act and the Public Works Act to unlock this, both in terms of access and capacity. But it's not something we've been successful in getting or bringing to a resolution with council on the basis of council's position is that third-party owner approvals are required, both in terms of capacity and access to land. I mean, just looking at an aerial view, it's a very logical and sensible connection, and it's not a long distance of land to connect to it either in terms of a pipeline. But unfortunately, it's not something we've been able to deliver without that buy-in. To add another, complete the story, there is a paper road running through the Jacks Point golf course that we're of the view potentially gives council some access control as well, but we haven't been successful in getting a connection through there. So I just agree with Nigel that it's something that has been pushed very hard, but we haven't been able to to get over the line. But sorry, Nigel, I think I interrupted you.
No, that is good. I guess I'd just probably like to add that while, you know, from the view of this hearing and this project, it is an appealing and, you know, a very feasible and, you know, I'd say low impact option that would be great if it was available from council's perspective, because it's the capacity that is available is limited, so it doesn't help the bigger picture of, you know, the wider, you know, development of this area. So I can understand from council's perspective why there wouldn't be perhaps too much motivation to go down that sort of path, because yes, it would help here and now, but it's not really addressing or it's not going to be a solution to any of the, you know, bigger area wide issues. So yeah, I can appreciate why from an engineering point of view, it wouldn't be perhaps a high priority.
And just to add to that, my understanding from sitting through many meetings on this, not from a technical, I don't bring a technical expertise, but I understand that the state highway option provides important resilience to the council wastewater network as well, in that it's a completely separate line in the event there was an issue. I'm not sure if that's something Nigel could talk to. But.
Yeah, that's entirely correct. And I guess it's also, you know, council are viewing it, I think, from the, you know, the context of development in this wider area as anticipated by the spatial plan. So they need a solution. They want a solution for that. And it's perhaps like they nearly don't want to get distracted by small scale interim solutions. I think would probably be fair to say, you know, albeit to the detriment of this project.
Thank you. I mean, it is not something we could make a recommendation on to progress, but I wanted to understand the background to it, because it did seem if you're first in, ready to go, and all of this development's coming later, why it could not be perhaps facilitated now. And the capacity for the other development would be provided through the line in the longer term, but you've obviously thoroughly explored that.
Yes, no, I couldn't agree more, but we have well and truly pushed that as far as we have been able.
Okay, thank you for that. That's helpful. No, thank you. We don't have any more questions now, so we could move to your last witness.
Thank you.
Thank you. Thanks, Nigel. Last but certainly not least, we've got Ms. Taylor, the planning witness, who's been jotting down notes as we've been going. So Ms. Taylor may ad-lib a little bit throughout the summary statement, just to respond to some points that have been raised, and is happy to take questions once she's worked through that.
I'll go through parts of my summary, but I will skip some paragraphs that are covered in legal submissions and they're a bit repetitive, but I'll give you the paragraph numbers as I go through. Just at paragraph 1, my full name is Carmen Wendy Taylor, and I'll take the rest of that paragraph and 2 to 3 is read. Okay with that? At paragraph 5, just the first sentence there, we know that the university is seeking a land use consent for its proposed Hakitakura redevelopment at Woolshed Bay. The rest of the paragraph provides an overview of that, which you've heard a few times. Under paragraph C now, just reiterate that the site is located in the Jacks Point Resort, not resource zone, under the operative district plan, and the Jacks Point zone under the proposed district plan. The site is subject to the structure plan under both the ODP and the proposed district plan. And under the structure plan, the area of the development within the site is classified as farm buildings and craft activity area under the operative plan, and open space residential activity area north, or OSR north, in the proposed district plan. Paragraph D over the page. I'll just pick out some sentences. The first one, the site and surrounding area is located within the urban growth boundary. The urban growth boundary identifies areas where development can and should occur while ensuring that urban development does not occur outside of the boundary. The intent for the future urban development within this area of Jack's Point is recognised in the spatial plan. It's been discussed a number of times, with the southern corridor identified as a future growth area for the district. And then in addition, the structure plan and PDP anticipates and provides for substantial further urban development at Homestead Bay. And this includes the town centre type environment with supporting marina activities and up to 39 residential units southeast of the town centre in the OSR south. E, just noting the first sentence there, due to the area's wastewater constraints, the university proposes to develop the Hakitakura facility in stages. And then I've outlined the stages in the following paragraphs. I don't think I need to repeat those. At paragraph G on page 3. Land use consent is required for the proposal in accordance with the operative and proposed plan rules and regulations under the National Environmental Standard for assessing and managing contaminants in soil to protect human health. Overall status is non-complying. In attachment 2 of my evidence, I've listed all the consent triggers with some just ad-libbing with notes as to the status of the various rules, given how things have changed since we lodged the application. I just note in the latter half of that paragraph that standard 41.5.4.20 of the PDP isn't relevant to this application, and that the section 42A report reaches the same conclusion. At paragraph 8, I'll just start at the second sentence. Also, although not assessed in the application and not identified in my brief of evidence dated 27 May, I note in the context of the permitted baseline that Rule 35.4.5 of the PDP, which is now operative, provides for temporary events subject to a range of conditions. Now, I haven't listed all the conditions here, but this includes, but is not limited to, no more than 7 such events in any calendar year where the event does not exceed 3 consecutive events for up to 500 people. Temporary events include a range of specific activities, including, and I've only noted a few here, but they include meetings, weddings, and uses which are similar in character. In my opinion, the permitted activity status for temporary events forms part of the permitted baseline. Paragraph I just list positive effects, but Mr. Leckie traversed that in his legal submission, so I won't go through that. Paragraph J, overall, based on the expert assessments, the evidence, the proposed management and mitigation conditions of consent, and the assessment contained in the application documentation, I consider that the potential adverse effects associated with the construction and operation of Hakitakura, when considered in the context of the area's existing and anticipated environment, will be minor. Paragraph K. The Section 40A report concludes that with the exception of the effects on landscape character, visual amenity, and wastewater, all other effects are minor or less than minor. As traversed fully in my evidence, I remain of the opinion that subject to the conditions, potential adverse effects of the proposal are appropriate when considering the nature of the site, which includes, and the proposal, including the proposed staging of the proposal, The nature of development anticipated under the PDP within the OSR North and the broader Homestead area. The inclusion of the site within the urban growth boundary and the identification of the site as an area for urban expansion under the spatial plan. The proposed landscape plan, which provides for retention and extensive existing vegetation and retention of extensive existing vegetation and substantial new planting. And the university's agreement to use a dark coloured stain on the staff and visitor accommodation units and to maintain vegetation within the lakeshore in front of the site. I remain of the opinion that potential adverse effects, both during the initial stage and subsequent stages of development associated with wastewater servicing at the site, subject to the now proposed conditions, are effectively avoided. On the above basis, contrary to the section 42A report, I consider that the adverse effects on landscape character, visual amenity and wastewater, including in relation to servicing of the subsequent stages of development, will be minor. Paragraph M, when considering the policy framework that is relevant to the university's proposal, I just want to note that I took a conservative approach and considered the policy framework of both the operative and proposed plans. Paragraph N, in my opinion, based on my assessment of relevant objectives and policies, as I provided in my evidence, the university's proposed redevelopment is consistent with and therefore not contrary to the relevant objectives and policies of both plans. The section 42A report considers that the proposal is inconsistent with a number of the PDP objectives and policies, mainly where they relate to the landscape considerations and the proposed reliance on the reticulated wastewater service for the subsequent stages of the development. Based on my assessment, I do not agree with the opinions expressed in the section 42A report in relation to the PDP policy framework. Irrespective, the section 42A report concludes that the university's proposal is not, in the round, contrary to the relevant objectives and policies of both plans. I agree with this conclusion, as it is my view that the proposal is consistent with the relevant policy framework of both plans. So on page 5, which I presume you're at, paragraph O, just the last sentence of that. In my opinion, based on my assessment of the higher order statutory planning documents, I consider the proposal is consistent with and therefore not contrary to the relevant provisions of the NPS urban development, the NPS freshwater management, and the partially operative and the proposed Otago regional policy statements. Paragraph 6. The section 40A report considers that the proposal will not set a precedent as the site and the proposal, when combined, are unique. However, the section 42A report concludes that the wastewater servicing, both during the initial and subsequent stages, has the potential to undermine confidence in the plan. And B, the proposal will enable the construction of unusable buildings as they are not connected to wastewater. Paragraph 7. Given the above conclusions of the section 42A report, within my evidence, I also considered the issue of precedent and plan integrity and the consistent administration of both plans. In my opinion, the issues raised in the section 40A report in relation to the plan integrity assessment do not exist. I agree with the section 42A report that the university's proposal is unique and consider that this uniqueness arises from a combination of factors, as I have noted at paragraph 149 of my evidence. As the proposal is consistent with the operative and proposed plan and it will not have an integrity effect, I consider the granting of consent will not set a precedent, will not impact on the integrity of the district plans, nor will it affect their consistent administration. At paragraph 8, I provide an overview of the controls and restrictions contained in the conditions, but these were traversed in legal submissions, so I won't go through those again. And at paragraph 9, the university's proposed development is consistent with and therefore not contrary to the relevant policy framework, the operative and proposed district plans, and the potential adverse effects of the proposal subject to the consent conditions have been assessed as being minor. The proposal therefore passes both tests of section 104D, and there is no barrier to granting the land use consent being sought by the university. Thank you.
Thank you, Ms. Taylor. During the break, Commissioner Sinclair and I discussed the differences between your evidence and Ms. Baker's section 42A, and we thought it would assist us greatly if you were able to conference on this and just provide us an agreed set of rules for the consent triggers. So your evidence, appendix 2, I think it is, does that, but Ms. Baker's section 42A has, I think, 9 rules as opposed to your 15, and whether you could spend some time reviewing that and then simply report back on the basis of your appendix 2 what you agree and what the outstanding reasons for consent that you don't agree on.
Happy to do that.
And then secondly, the same for the objectives and policies, not to analyse them again, but just to highlight what the relevant objectives and policies are. Your evidence was very thorough and set out at some length. So we'd just appreciate a simple list of if there's any disagreement on policies that are or are not relevant to our consideration.
Okay.
Thank you. Now, Commissioner Sinclair.
I had quite a few questions, but they have been answered along the way. So thank you for your team for that. So the ones that I've got outstanding, one relates to just the spatial plan. Where does it, if you could just remind me where it fits into our planning framework and our considerations? Would it come under as an other matter?
It would come in as another matter at this point in time. The spatial plan identifies that it's not a plan giving effect to the NPS urban development, but it is setting the scene for what's to follow.
Okay, and what about the iwi management plans? Is that similar? Would they be other matters?
Yes, and they were assessed in the application.
Thank you. Just in your descriptions of the zonings that apply under ODP and PDP, I didn't see that you had recognised that the lake was an outstanding natural landscape. And I just wondered if you were aware of that and if it would change your opinion in any way, or if you had actually considered that in your assessment.
I do recognise that the lake is a ONL under the PDP. I don't think it would change my assessment based on Mr. Espy's technical evidence.
The other question I just had on, was there any update since your evidence on where things are at with the regional council in terms of the applications that have been lodged?
There has been a site visit last week, which Mr. Lloyd attended with their technical advisor and a council officer representative, and there's been agreement to update the erosion control and sediment plans and provide it to council, hasn't there?
Yes, and provide some more commentary around staging.
Yeah.
You, in your draft set of conditions, you refer to, you've put the archaeological authority as an advice note, but Mr. Leakey in his opening submissions referred to it as a condition. I take it there's a condition above it to say that you have to comply with it, and then you've put the requirement as an advice note. Just wanted to make sure you both are on the same page, that I see it appropriate as an advice note the way Ms. Taylor has it. I just wanted to make sure I understood what Mr. Leakey was saying, if it was different.
I can. Actually, on me to clarify my own statement there. It's a good question. I was my comments more that if it's required, it'll be required anyway under the Act. So I wasn't meaning in terms of it being a condition, it will just be a requirement regardless. So I'm comfortable with the approach of Ms. Taylor as well. Having it in place.
Thank you for clarifying that. Taylor, you would have heard my question about the traffic management plan and if there was a review loop for effectiveness. Would you support that?
Yes, I would support that. When you made that comment, I went and looked and saw we didn't have that. If the management plan was reviewed and updated by the university, then providing that to council for approval and that loop continuing as given that the document's a live document is appropriate.
Right. Would your support of a general review condition for functions and facilities and noise, would it extend that far, or would you limit it just to the traffic management plan?
So you're talking a general section 128 review condition?
Yes, yes.
I had assumed that council would put that on as one of their standard administrative conditions anyway, right. So. Okay.
I just see on the condition, where is it? Condition 13, you have removed the words, it was about infrastructure and costs being borne by the consent holder, and you haven't included those words. I just wondered if you could explain why those words were deleted.
It's mainly because that's a, it doesn't need to be a consent compliance condition, though that will be a matter of fact anyway. And in terms of development contributions, that's under the Local Government Act, so it didn't have to be a consent condition. But I realise it's council's standard conditions, and it's there.
That's okay, thank you. No, that was all I had, Ms. Taylor. Thank you.
Thank you. So just going back to the advice Mr. Espy gave us about the interpretation of the landscape guidelines, and obviously your evidence relies on Mr. Espy's evaluation. If, however, the effects were significant, from a planning perspective, are we required to consider alternatives, or is there any other matters we'd need to consider if that was our finding?
If your finding is that the effects are significant, then yes, an alternatives assessment is required.
Thank you. Then I think from the discussion in response to Commissioner Sinclair's questions, there's no formal section 92 on the regional consents at this point.
No, it's more of an informal process at the moment that we're going to work with regional council.
And then the other matter we discussed and Commissioner Sinclair asked Mr. Espy was whether there was a possibility that some of the structural planting, the beech trees, could be offered at an earlier stage and potentially amendment to condition 14. Do you have a view on that, and would you?
I would support that, and there.
Support that.
We have, discussed it at lunchtime. I think there's general agreement to that principle.
Okay. Scrolling through, I'm afraid, checking for anything that's not answered. Sorry, one last check. Did you have any comments on the 10-year lapse date from a planning perspective and your experience of that length of lapse date?
Not at all. I have prepared a number of applications seeking a 10-year non-lapsing date, especially for significant developments where there's a whole lot of processes to go through before there's the potential for the give effect to requirement under section 125. Did I say that one? Yeah. I nearly said 124.
One of the questions I asked earlier was what would the status be of removing any of the trees on the Lynn's land? Would that require a consent?
I haven't looked at it, but in terms of the university and its activity, proposed condition 15, I think, puts in place a mitigation if that were to occur, and even if it was trimming, because that refers to or entirely or substantially removed, and that places an obligation on the university to carry out actions, which has a cost to them, which means that I cannot envisage the university removing trees to improve their views.
Yes, it was more just trying to understand if it was, say, a discretionary or non-complying activity, that it may, given the natural character values, be a difficult bar to cross to get a consent if required to remove trees from that location. So it was just really trying to understand the likelihood of success of any such application. It's a hypothetical. But,
yeah, sorry, I haven't looked at the rules, but if need be, we can discuss it on conferencing with Ms. Baker if needed.
With the staging, so you've amended the condition now so that it tied to stage 2's tied to the commencement of the construction. Sorry, I'm just finding the condition here.
Condition 9.
So connect. So potentially Mr. Lloyd told us that the construction could take 3 years, or conservatively, for the wastewater line. So do you see any issue with building the buildings and having them sitting there for 3 years? Or I'm not sure what the length of construction period would be. I should have perhaps asked Mr. Ritchie. But I was just wondering why that trigger was chosen, that you're allowed to do stage 2 when the construction starts, and that might take 3 years.
I think there's a reality to this condition that the university, any developer, wouldn't invest money to do some works for something they can't use in a timely manner. So this condition is purely designed for the university to realise it can proceed with subsequent stages because it has a right to connect and the reticulation is coming, but then it gives them time to do detailed design, a water contract, take the construction activity, and I would see that there would be building consents, purely achieve an alignment so that as soon as they're connected, they can operate. And yeah, that's what we're trying to articulate.
Okay. Now, the condition that's proposed with the large events, can you just remind me how the 100 was decided on as the threshold for what qualifies as a large event?
I think it was discussed in one of the RFIs. No. Sorry, I'm just going back to one of the responses to the RFIs.
Because I was wondering what the difference between 99 and 100 is, and so what the magic of selecting 100 is. And you need to draw a line somewhere, but
Yeah.
I was interested to understand that.
So the number of events evolved out of the university's assessment of its business case, and this is discussed in the first part 1 RFI in response to questions 1 to 4, or what question 1 of the request for further information. So the numbers are evolved out of the university's business case, and at page 3 of the RFI, the university considers that these facilities, this is for private events, will be available for such events around 11 times a year, 20 times a year. And then the large events, the university's business case was that, and this is on page 2, about halfway down, advised that it would cater up to 120 people in the lecture theatre and up to 50 to 60 people in the wall shed, but not at the same time. Therefore, it is, so it was operational considerations that defined the maximum numbers, and they also anticipated that they would have around 11 large events, which were 100 people or more. Yeah, 11 large university events of 100 people or more.
And there are constraints around fire.
Yeah, okay. And Mr. Ritchie's just added there were some fire safety constraints that also assisted in quantifying those limits.
So the evidence you're relying on, if Minister Tribhutham, is that it's not, the main noise impact is from vehicles using the access.
Yeah.
And so it's not going to be highly annoying or a great annoyance to the residential properties there. I'm just interested in, this condition is cast as a noise mitigation condition, but equally you could have what's not a large event, a small event of 99 people, and you could do one of those every night. And I just wonder, from an effects point of view, what the difference is.
Sorry, so this question came back through noise questions RFI, and there's comment in the part 3 response, starting at page 10 of the September 2021 RFI. And it's also acoustic engineering services. There's an attachment 3E. Address this issue. I'm just trying to find where he talks about it. sorry, the acoustic engineering services on page 4 of their report just talk about the number of permitted events per year and the return period and the times of the events is all contributing to the noise mitigation.
So then should there be a condition overall capping all events, or?
Yes, it could move into a general condition. But it also plays a role in mitigating the noise from traffic movements, but so do the operating hours.
It's just I'm really struggling to see how you could just limiting it to 31 with 100 people, but then having 100 events with 99 people, whether just relying on operating hours is sufficient mitigation, and whether there should be a cap on total events.
I think this is the university generally, in terms of the business case, from memory, that most of your events would be 60 people or less was the business case
and it's
criteria.
At the initial stage, condition 4A would kick in anyway around a cap of 65 as well as an additional layer to that mitigation.
Sorry, which condition is that? 4A?
That's 4A. So that's just a blanket cap of 65 people per event.
For the initial stage.
I'm more thinking once the full development occurs, it does seem quite odd to restrict the number of events over 100, but have unlimited number of events. And if there is a business case, so I understand that some level of private events are required to fund and operate the facility, but it's not clear to me that these other events, once the development is fully completed, might not.
To clarify, and maybe the condition 34. So what condition 34 is to say that all private events fall into this category. There's no number restriction for private events. So all private events would account as an event, as a control under this condition. And then it's the large events by the university that exceed 100. So together, they equal the 31. So all private events plus the large university events over 100 people. So it could be a private event of 30 people would be subject to this condition.
I do find the condition very unclear as to what it's seeking to achieve. Sorry to.
Yeah. No, it's okay. We're laughing a bit at our end. We had the same conversation yesterday, and I just think we can we'll have another look at that condition because I had the same interpretation issue myself. So we'll look at that with Ms. Taylor.
I mean, perhaps it could be addressed or given thought to in your reply, but to what extent, given the evidence on noise, is just seems unclear. And so we heard that there were 20 events private, 11 university ones, but there's no condition requiring that or capping that. And in this condition, the private events could only be 30 people, but the university ones, it seems unclear. So I'd welcome some suggestions on what it's intended there.
Yeah, we'll consider that.
we got there on my question. Thank you. If I'm not wrong, that is your last witness.
It is my last witness. Thank you, Commissioner. Just before I briefly pass the talking stick, there is one point which I'll address in closing, if I may, but it's something we checked over lunch, which was around the Commissioner's comments about those visual aids from the architects. And your struggle to find them, which alarmingly led us down a track to the notification bundle, which doesn't seem to have them in them, despite them being lodged with the application. So there's no issue of scope or anything of that nature from my perspective, and that they're visual aids to help assess effects. But in saying that, we'd like the opportunity to just do a full audit to make sure that everything's on the table from your perspective. So we'll do that. We'll get that underway after today, and we can report back in our right of reply if that's okay on that. But from a look over lunch, it looks to be those architectural visuals superimposing the buildings on the existing built form that don't seem to be in the notification bundle, which maybe is what is in front of the Commissioners.
Yes.
Or not in front of the Commissioners, as the case may be.
They are now, but belatedly.
Yeah. So they're in the application, but yeah, not. Anyway, they're in the bundle now.
Mr. Vicky, our ones are just titled application is notified 1 and then application is notified 2. And I can't see them.
I'm pleased you raised it. We'll look into that because obviously we want you to have everything that's there. So we'll report back on that. And I've probably been implicit, but just to signal, I appreciate the offer of a written reply, and I'd accept that if that's okay. There's a bit to cover, and also there's that separate conferencing as well. And I think the conferencing could then feed into my right of reply. So we can talk about it perhaps at the end of the day, but perhaps we have the conferencing and then a 5 working day period or something before the right of reply to follow.
Yes, but I wouldn't want to put Ms. Baker on the spot and commit to a time frame without asking her what's realistic, because I'm conscious she's very busy.
Absolutely, we're happy to work with the Ms. Baker in the room on a time frame that works for everyone on that.
That sounds good, thank you.
So we'll, no, that's all right. You potentially haven't heard the end of me just briefly, in that I'm assuming from the Commissioner's perspective, the next part of the day would be the submitters, and that would be the Jardines, if I might got that right.
That's correct, available.
So unfortunately, Mrs. Jardines not well today, so hasn't been able to be here, but Dick is here in the boardroom with us. And Gillian has asked me to read out her the document that Dick and Gillian filed yesterday. Hopefully the Commissioners have got that.
Yes, we do. Thank you.
So if you're comfortable with that, I'll just briefly change hats. I also act for Dick and Gillian, so I'm quite comfortable reading out their statement on their behalf, and I can take questions, and Dick can take any questions that may assist. So if that is all okay procedurally, shall I briefly read through the presentation from Dick and Gillian now?
Yes, thank you.
So as advised to Council officers, the Dick and Gillian wish to present the supplementary statement from their original submission. So firstly, on the vision, we gifted this land to the University of Otago, not just to benefit the university, but also Queenstown and New Zealand as a whole. We had a vision that the university would create a facility known throughout the world. Hakitakura would become a centre of academic excellence, attracting globally renowned academics and providing the petri dish for a regional culture of innovation and entrepreneurship. We are bitterly disappointed that the Queenstown Lakes District Council does not aspire to share such a vision. On wastewater, we fully accept that appropriate disposal of wastewater is a legitimate concern, but we believe that the proposed stage solution for off-site removal is appropriate. And from our practical experience over the years with non-reticulated wastewater systems, entirely practical. Declining consent would mean the entire vision will then wholly depend on the provision of a reticulated wastewater solution. Who knows when that will be? The council has no immediate plan for such a system, even though it's in their long-term plan. Shortly, that solution will pass out of the control of council and transfer to a yet to be formed Three Waters entity. The uncertainty, that will be created will inevitably mean, at the least, further delay. So under the heading consistency of decision making by council, the Queenstown Lakes area has seen many proposals consented by council with wastewater solutions either unresolved or resolved by on-site systems, mostly septic tanks with on-site disposal fields. The most notable example is nearby Coneburn development, where there's an intensive urban residential development for hundreds of permanently occupied homes, was approved without public notification and with considerable storm and wastewater issues. We understand these are yet to be resolved. If Coburn could be consented without a council reticulated wastewater scheme, what is the issue here with a low density proposal for off-site removal? So that's the presentation for Dick and Gillian that was circulated, and happy to take questions either through Dick or through me on that.
Thank you, Commissioner Sung.
I just had one through you, Mr. Leakey. Do you know what the issue is with the Coneburn?
That's my question.
What the stormwater and wastewater issues there that are yet to be resolved? Do you have any more information on that?
I understand there has had to be a lot of groundworks done in relation to geotech ground quality issues at the Coneburn development. That's been underway, I'd say, for at least the last year. There's been a lot of trucking movements, fill being taken out and new fill being brought in. And that's a point that's sort of still being addressed to unlock that Coneburn development, despite it having been granted consent, as Gillian and Dick say, a long time ago, non-notified. But that I suspect that's the key concern there.
And it was a resource consent, it wasn't an SHA?
Coburn was SHA. Yes. Coburn was SHA. Yeah. Yeah.
That was all I had for questions.
Thank you. I don't have any further questions either, other than just, no, I think that, no, I don't have any questions, thank you, but that was clear.
Thank you. Thank you. So I'll mute at our end and we'll pass back to the council.
Right. Now, would you like to break now? Or how is everyone feeling? Do we want to push through or have a short break before we discuss with the officers and hear from them? Ms. Baker, would you like to proceed now, or would you?
We're ready to proceed fundamentally. Myself, Mr. Pridham and Mr. Denny are in attendance, as you can see, so we can proceed. And Mr. Exeter is probably about half an hour away, so I propose to call him last. So potentially he could be after the break. So it might be an idea for us to proceed and have a break just before Mr. Exeter, if that suits you, Commission.
So what I would like to do is just perhaps first, so we don't duplicate questions and things, is to hear from each of you your response to what you've heard today, and if there's any changes to your or comments to your section 42A report opinions, and then depending on your summary and views there, then we will cover questions once we hear from you. If there's any change in your opinions there. So perhaps we start with Mr. Denny or Mr. Pridham.
That sounds good. We just might not have Mr. Exeter, but he's basically confirming his evidence. So
Yes.
potentially you don't need to hear from him in the first round.
Yeah, he can have his own little feature piece at the end.
Yes.
Yes, okay. So would Mr. Denny or Mr. Pridham like to lead off?
I'm going to suggest Mr. Denny.
Thank you, Mr. Denny. So it would help us, Mr. Denny, if you could just tell us, based on the evidence we've heard this morning and this afternoon, if there's any changes to your recommendations in your report or not, and any comments on what you've heard.
Can you hear me okay?
Yes, thank you.
Yes, I've made a few notes about stuff I've heard this morning. First thing I want to raise is something in Mr. Espy's evidence about the adjoining open space activity area OSF under the rule 41.5.4.10 in terms of the percentage area of vegetation cover to be planted prior to development on the OSR, which is 80%. And that rule refers to freehold land. And under my review assessment, I consider that site all to be freehold land, but I'm not sure what the actual status of that land is. So that may change things slightly in terms of the context. My understanding under Mr. Espy's evidence, it's all Crown land, but even as Crown land, I'm not sure what the status of land is, if it's reserved land under the Reserves Act or what it is. So,
could I just leap in there, sorry to break, but I thought I understood this morning that I heard that Ms. Baker and the applicants were in agreement that that rule did not apply, but is that the other rule? That was the 80% rule. The 80% rule. This one's the 50%. Okay. Sorry to butt in.
That's all right. I've referred to that in my report. That's my expected sort of outcome for that area of landscape, but there appears to be some uncertainty around that because of that freehold condition there. I note that the colour of the cladding on the buildings has changed with a removal of the silver weathering replaced by a black tint, which I think is appropriate. That'll reduce the visibility of the buildings over longer distances, where that contrast will stand out. So there'll be more recessive in the landscape and board of use, which is acknowledged. I've been through the proposed landscape conditions. To my mind, I don't believe they're measurable conditions or enforceable. So I wouldn't support them as they're currently written.
Would you just expand on that for us? What particular aspects do you say as not being enforceable?
Okay. Let's grab the slide there. So condition, was it 14? It's just some of the wording, stuff like managing pest grazing of new plants is reasonably managed. There's no way to measure that in terms of what's reasonably managed. Usually these conditions, we sort of specify some sort of threshold or some sort of performance standard that we can tick off that's been achieved. But that doesn't give us that ability to do that, so you can't really enforce that.
So would you have a standard condition you would normally recommend to the planner that would be more specific?
Yeah, I've got lots of standard conditions that we could apply to a lot of other stuff. These other stuff there in terms about managing pests and stuff, and down on this side, I'm aware there's goats and there's also deer that are a problem with planting as well, so that need to be managed at some point. That's not really incorporated. There's kind of a lack of detail in the conditions to accommodate all those sort of things that happen on these sites. So to my mind, there should be a lot more detailed conditions to support what's proposed. And in regard to condition 15, again, the word sort of entirely or substantially removed. Must submit a planning plan for approval showing a revegetation regime which will achieve appropriate mitigation of the visual effects of proposed activities. Again, it's not a measurable condition. There's no standard there to achieve to say you've done that. It's really up for argument to what point do you achieve appropriate mitigation. And it's ideally it's something that should be resolved now, not at a later date. So I don't believe that condition is particularly useful. It doesn't give much assurance in terms of maintaining the mitigation values there now, yes.
So would it be of assistance to give greater detail to what's there now and to achieve the same or better? So you might have to specify heights, minimum heights of vegetation at maturity, for example. Would that be a way of making it more specific?
Well, I think you need to do a detailed survey of what's there now. Yeah. And to me, if you remove any of the native vegetation there, it needs to replace. But again, there's also a problem with that condition and that it's all on land, it's not in the applicant's control. So how do you enforce that? I guess there needs to be some sign up from that land manager as such, but there's none of that proposed in the application I'm aware of. So it's problematic. Do you wish me to carry on these other points?
Yes, thank you.
Just a general comment on the landscape plan that's been submitted. Typically for a development of this nature, of this size, you'd expect to have quite a resolved landscape plan with a lot more detail on it, showing hard landscape areas, what's happening between spaces between buildings, what's happening between spaces between where there's lawn and where there's a boundary, and all those things shown on a plan in detail. The plan I consider to be very light in that sort of detail, and also the response to mitigating effects and response to what's generally anticipated in activity, again, I think is very light. So to my mind, the landscape plan doesn't really support the application particularly well. There's just, just as I mentioned before, there's a significant reliance on mitigation along the foreshore and planning that's outside the applicant's control. And just as we discussed, I think there needs to be some sort of assurance that that level of mitigation can be retained in one form or another. I think I mentioned in my report, one possibility is to do additional planning within the site across the boundary, but you're very constrained because you're so close to the buildings between the boundary and buildings. And there's also things like fire management to consider as well, which I think will be a potential issue down here. There was comment on the QLD spatial plan, which was presented this morning. There was nothing in there that I could see that would change my view of what the potential outcomes would be down here. Most of the areas of intensification I could see on that plan were further east. And as far as I could see, there was still this graduation between areas of intensification through to neighbouring O&L with open space buffers in between, which the structure plan currently shows. As far as I could see in that document, there was no suggested changes from that in this location of the site. In other places it would be, but in terms of the particular site here, I didn't see any changes there. And just on that, I think it's important to note that those areas of intensification, such as the village area close to this site, the outlook from those areas to the site is important. And that's why you have the open space areas there and you have an O&L behind. So I don't think there's an expectation those areas can sprawl out as such, or that type of character can be consistent across those areas. There's also a value attached to village areas looking out across the landscape, which needs to be considered. And I think that's quite relevant to this development. I think it's about it for me, to be honest. Happy to answer any questions.
Thank you, Commissioner Singh.
Thanks, Mr. Denny. Just on that point you made about the outlook from the village back to the site, You would have heard, hopefully, the discussion this morning about the beech trees effectively creating quite a high level of screening from that eastern boundary. Does that satisfy any of your concerns, or is there more of a view? Does that sort of bypass the view a little bit?
I disagree. I think the number of beech trees, it sounds like a lot, 100, but it's not. On a site like this, it'll disappear quite rapidly, that number of trees. I think you need to do a lot more planting, and the bay actually drops around and goes south, the beach line. So you're looking not across from east, you're looking more from southeast across. So you still have those views through. And the vegetation between the buildings and the foreshore is not much there. And if you look at the aerial photograph of Mr. Espy's evidence of the landscape plan overlay, the aerial photograph shows a lot of vegetation on the site, but none of that's identified in the application. Well, some of it is, but not to the extent that's there existing. So we take that away and just look at the landscape plan. It's pretty sparse between the buildings and the foreshore. And the only area of bulk planting is existing trees is that strip along the front, which is outside the site. So it's kind of difficult place there in terms of that screening and stuff. And I think there is scope to do additional trees in front of the buildings. I don't think it needs to screen the buildings. I don't think that's expected, but I do believe there needs to be an integrated context that's achieved. And I think it can be achieved, it's just not shown in this application.
So just to summarise that, just some more bolstered up that landscape plan would appease some of your concerns.
Yeah, look, yes. Yeah, this is kind of the reason I didn't do conditions, because there's such a large scope of what you potentially should do at this site that to my mind, it needs a pretty large sort of redesign of the landscape approach. Looking at that 50% criteria that's sort of over this activity area, the site's roughly, just a rough measurement, about 20,000 square metres. So you're looking at 10,000 square metres of planting to achieve that. And I think that's kind of a realistic figure for integrating this site. What's expected adjacent to the O&L. What's presented here is well below that figure.
Do you have any idea of the percentage of the figure that they're proposing on that other side? Or is it? Well,
yeah, it's hard to quantify for drawing. I mean, there's some existing vegetation there that is of value, but that 50% also refers to native planting. It doesn't refer to existing exotic trees. So if you take that out of the equation, it's probably, I don't know, actually within the sites, it's probably quite high. It's probably like 5% or something like that. But, yeah. But I mean, the applicant might be able to give you more detailed figures on that using their CAD and whatever.
We would have heard our discussion this morning about structural landscaping in place before the stage 2 is built. Do you have any response to that?
Absolutely. I think there should be planning done prior to development. I think there's scope to do it on this site. I think you could stage it, planting as well. Ideally, you'd go for the periphery areas, preferably towards the foreshore, and get that planting underway. I think that's the expectation of the activity area too. It talks about that 50% criteria prior to development. So I think it's feasible to do, and I think it's definitely expected to be done as well. Also, you need to allow areas for construction activity, and I think you can accommodate both on the site.
And Mr. Denny, the 50% rule that the planners tell me is under appeal, do you know if there was a corresponding rule in the ODP?
I don't think there is.
Right.
But top of my head, I'm not completely sure.
Maybe Ms. Bacon might be able to fill us in of what was under the ODP in terms of requiring for planting. And my last question was, with the change in colour, I heard you say that it makes a difference for longer views, more distant views. Does it do anything for shorter distant views from the lake?
Well, it does to a degree, but I think the closer you get to a building, it's obvious that it's a building, and it's going to always be the general bulk and form in your face as such is going to be present. So the colour does tone it down a bit, and plus it's south facing, so it's not going to be directly in the sunlight. but the real effect is longer distance. Do you need the pale colours? They stand out over longer distances when you're looking across the landscape. If you look from this point, actually looking south down the lake, there used to be a hay barn down near Kinloch Way that used to stand out on certain days. And over those long distances, those sort of silvery, that's metallic, but in some cases, timber things can pop out as such. This will reduce that over those long distance use, especially from the highway stuff, which I think is a positive outcome.
Thank you, Mr. Denny. That was all I had.
Thank you. Now, just going back to, we heard from Mr. Espy after lunch about the NZILA guidelines and the translation of the evaluation of moderate to high to being more than minor. So I'm just wanting to clarify for you that answer that question from Ms. Baker, that the effects from a landscape and visual amenity point of view are not considered by you to be significant. Is that so we talked about you've assessed the effects as moderate to high, and then yes, Ms. Baker has translated that to significant in the planning sense. But as I understand it from hearing from Mr. Espy after lunch, that the NZILA guideline says that it's only when it's high or very high that from a planning sense that those impacts would be considered as significant.
Yeah, well, under that definition in my report, it's more than minor, I guess you'd say, moderate high visual effects.
Sorry, I didn't catch that.
Yeah, as per my report, it's more than minor. It fits with that more than minor criteria.
Thank you, but not significant.
No.
Now, you gave in your report, there were some quite specific comments on the parking area needing more landscaping, and I think you've touched on that in your comments to us, that you would expect a greater level of detail in the landscape plan. I was just interested if there was a specific list of things you think that are missing, if you could just go through that for us of what you think is missing.
Okay. I guess ideally you'd have you identify a structural planning of where the trees are going, specimen trees for mitigation, which kind of does show on this plan, and then you'd be showing drifts of indigenous lower vegetation, flaxes, pittosporum type of stuff. And when you're looking at sort of roughly 10,000 square metres of planting, it's quite a lot of area to cover. So you expect to see that on it, and then you'd like to, what I'd prefer to see would be all the hard landscaping details, so the retaining walls, pathways and all that sort of carry on, access to the beach, pathways and all that sort of thing. And then probably one of the key things for me is the spaces between what's happening between the buildings and the planting and the foreshore. There's lots of areas that aren't shown, which are not defined as to what's happening there. And I know there was a comment this morning about a lot of the existing vegetation is not intended to be removed, but if it's not showing on the plan, there's nothing there to say that it won't be removed. There's nothing there to show on the plan as what it would be replaced with. So it's very hard to understand a context outcome for the site when a lot of those gaps aren't filled or explained, I guess you could say. My expectation was that you'd have a pretty resolved landscape plan for the whole site, which clearly shows what each space is doing, what each space comprises of, what's the structural level of planting, trees, shrubs, down to grass or meadow or lawns, and all that sort of carry on is fully explained. It's not that clear on this plan, I don't believe.
Thank you. One of the things we heard this morning from Mr. Ritchie and Mr. Espy was the intention to have viewing shafts out from the windows of the buildings. In your opinion, is there scope to enhance the planting further in front of the buildings And is there a need to do so from your perspective?
Yeah, I think it's always preferable to have a landscape plan that does show view shafts. There's no expectation of screen buildings here. And when you do show view shafts, you get some assurance everything outside the view shaft is going to be stayed in place and it's going to assist in context, landscape context and mitigation. So my preference would be to actually show the view shafts. And I think there's scope around the lecture theatre area as well to have potentially some of those trees limbed up, so you do get some glimpses out to the lake. I don't think there's any problem with that. The scale of trees down there are quite tall, and that's the bulk and form you want to have in front of that size building. So that's the value to be retained. There is scope for planting in front of the buildings, but there are a few constructions there. One, because the buildings are so close to the property boundary. And the other thing, which is not really touched upon in great detail, is this virus issue, and it's becoming an increasing issue in the district. It's something I try to ensure with every landscape plan we do in terms of mitigation, that the planting we do is assured to stay there. That's not going to be removed at a later date because of fire hazard. And the New Zealand Fire and Emergencies Service put out general guidelines on this. Their guidelines are a 10-metre clear space around buildings, and 30 metres out, everything else is low flammability species. And to my mind, you should be applying those sort of principles here. One, because there's quite a lot of vegetation potentially there, and also you've got a public space foreshore directly next to the site. So there is some potential fire risk which happens, which is most of the recent fires in the district tend to originate from recreation reserve or public access areas and getting along the lake edges and spread that way. So I think it needs to be a consideration in the planning design. And I think you can do it with a site. It's just not evident in the application.
And in terms of the planting species selected, what is your opinion on the appropriateness from a natural character perspective, given your comments about the foreshore and the lake? Are you satisfied with the species of planting selected?
Oh yeah, I think they're all appropriate species. These couple of species have been retained, some of the exotic species, well, one in particular, but I don't think it should be identified, and that's silver birch. Silver birch is the highest allergenic tree species you can get. It's also an invasive species next to an O&L context, so I don't think that needs to be protected on the plan. In terms of the native species, I think they're all fine. They'd be fine down there. Ideally, it'd be a bit more diversity because that 50% rule looks at ecological biodiversity. So I think there's room to scope to increase the diversity in there. But apart from that, I think they're doing fine.
Thank you. Now, one of the main points of disagreement between yourself and Mr. Espy is the eastern part of the site, and in his evidence he talks about the 10 residential units and that they could in fact be clustered, and you've acknowledged that I think it's paragraph 16 of your report. So I was just trying to reconcile, if they could be clustered in this location where these buildings are shown, what is the difference between residential buildings clustered at this eastern part of the site and this development proposal?
Yeah, that's an interesting question. I suppose the key difference is that scenario will result in the rest of the activity area being clear of buildings, supposedly, in an open space context. So, and then you have the buildings clustered against the foreshore. What you're saying is similar to what's proposed here, but I still believe there's expectations within the policies of the zone for integration. It talks about visual amenity and all that sort of carry-on, that those outcomes are still expected, and that 50% vegetation cover is also expected. So those buildings be set in that context. It's difficult to comment on about having a proposal in front of me, but I still believe there are expectations for a higher level of integration, and than what's currently presented in this proposal, I guess you'd say. Just on that, it's interesting to note that the comments this morning about the lecture theatre building and the trees in front of that unlikely to be removed because of the high winds from the lake. But at the same time, we've got a potential scenario of cluster development by the lake for views. So there's a contradiction there. I think anyone getting to the lake, views of the lake are highly desirable, and I think there's always a desire to maintain views. So there's almost a contradiction there between shelter and views. But I think you can accommodate screening development to appropriate level and having views on this scenario. It's just not presented in this application.
Thank you. No, that's all my questions. Thank you, Mr. Denny. Now, Mr. Pridham, would you like to turn on your camera and mic?
Hello. Can you hear me?
Yes, thank you. Would you like to give a summary and comments on anything you heard this morning, and then we'll move to questions after that?
Yes, of course. Sounds good. I stand by the information in my engineering report. The information I've heard this morning hasn't changed any of my assessment. I would like to start off by just maybe expanding a wee bit on why I came to the conclusion that the wastewater solution for the second stage is not a feasible option. Firstly, obviously, they're proposing to dispose of wastewater to the council reticulated network, and currently there is no council network to connect into. I acknowledge that the Southern Corridor wastewater main is in the 10-year LTP. However, in my opinion, this provides no guarantee that infrastructure will actually be installed in 10 years' time, as political views, economic environments, and management organisations are all likely to change. An example of this is the Glenorchy Community Wastewater Disposal System, which was in the 3-year LTP and scheduled to be installed around 2016, is my understanding. However, still no community wastewater disposal system exists in Glenorchy. As a council engineer, we can only assess what's in front of us based on what's in the ground at the current time. For this reason, I do not consider the wastewater disposal option to be feasible. I would also like to discuss the condition that the applicants have proposed in relation to no development until construction is underway on the pipeline. If the Commission were of a mind to grant this consent, I wouldn't be opposed to such a condition. However, I think further thought is needed to avoid the situation where the development is complete and the pipeline itself isn't. This could lead to completed buildings being unable to connect into wastewater infrastructure and may resort to trucking or trucking higher volumes, which would be undesirable. In my opinion, the Southern Corridor pipeline needs to be complete from Frankton to Homestead Bay State Highway boundary or the marina. From there, a connection. So perhaps the condition should need to state that the Southern Corridor pipeline should be live and commissioned. From there, a connection would need to be made from the subject site to Homestead Bay land to the trunk main, and any third-party approval would need to be obtained for any connections through neighbouring properties. Happy to take any more questions.
Did you have hear the discussion earlier about the Local Government Act and the way that council can facilitate these connections over third-party properties? And do you have any comment on that?
Yes, I did hear that discussion. In my experience with the council, we've always sought to get those third-party approvals prior to making any connections. I understand that we may have the powers to do that, but if we went around doing that all over the place, I think council would be viewed unfavourably by those affected parties, potentially. So maybe that is something to consider, yeah.
In your experience, are those powers ever used? Have they ever been used by council?
Not while I've been at the council, no.
Okay, thank you. Now, Commissioner Sinclair, do you have any questions?
Most of my questions have just been answered, so thank you. Just have you, just with that Glenorchy example you gave, are you aware of any applications that have similar conditions that have been approved and awaiting connection in the Glenorchy area? Has that ever been used before?
I'm not aware of any that have been approved in the Glenorchy area because of the uncertainty of when this infrastructure is going to be installed. I guess to install, impose a condition like that, you've got to be absolutely certain as to when this infrastructure is going in the ground. There has been situations where like the early stages of Henleys have pumped large volumes from a wet well before the pump station has been commissioned. So they've trucked reasonably large volumes of wastewater, but that's only over a short time, and it's not really desirable outcome if you can avoid it wherever possible.
Just so I'm clear, what you said before, in terms of the condition that's been proposed along the lines of that they just have to commence, your recommendation would be that there could be some support from you if there was rewording to say that the infrastructure is in and to a certain point.
Yep, correct. If it was live and commissioned, I think we could support that. Yeah.
Right. Okay. Thank you.
But I guess we'd have to be careful to avoid a situation where for any reason the Southern Pipeline fell through, and then I guess you're left with an initial stage to the development, which is shifted from being a short-term having a short-term wastewater solution, which is going to turn then into a long-term solution, obviously, because they can't proceed into the next stage. So then potentially they may need to look at another option for their wastewater disposal instead of resulting on having to truck for a long period of time.
So just to clarify, you see the main effects as traffic effects from trucking it, or is there some other effect of concern?
Yes, in short, obviously the transport effects with trucks on the road and carbon emissions, but also there's risks of spillage when you're dealing with removing waste out of manholes with a sucker truck. You're relying on there being no human or machine error in that operation. It's often done in situations in remote settings where residential houses have no other ways of disposing of their wastewater, and they've exhausted all other options, and that's the only option that's available to them. So it's sort of a last resort for council.
Now, one of the things we discussed this morning with Mr. Kelly, was the sightlines from the access point, and because of the road being a 40km/h road, he was confident that they were acceptable, and I just wish to check that with you, what your view is of that.
I'm for transport related items, I'm relying heavily on our transport expert, Katie Duggan from WSP Consultants, and I think we do have her phone number, and we might be able to give her a bit of a call just to see if she could provide some feedback on that, because I think she's probably the best person for that.
Sorry, maybe I should interrupt there. We do have her available if you want to question her. Yeah.
Well, however, we do not have a report from her, is that correct?
I think it's attached to Mr. Pridham's report. Is that correct, Mr. Pridham?
I don't know if I attached it. However, it should be on file.
Okay.
It should be on file in IDOCS, and
Apologies.
I can certainly get it to you.
Okay, apologies. We won't call Miss Duggan.
My report incorporated a lot of her recommendations. So,
could I just ask Mr. Leakey a question? Would you have any objection to us seeking clarification on this and the assistance of having one less issue in dispute?
I think to have one less issue in dispute, that's fine. I would quite like to see the report, but yeah, I don't have an issue with questions being asked to clarify that.
Okay. Would you want your expert to have the ability to comment on that report, or you just wish to see it?
No, happy to, in the interest of just letting this move on today, if I could just see that before I file my right of reply, I'm quite comfortable with that.
Okay, so perhaps if Ms. Anderson could circulate that to the applicant, and perhaps if we could, I'm not sure if it's best now if Mr. Pridham goes offline and checks the answer and reports back, or how would you like to do that?
If Ms. oh, sorry, that probably wasn't a question for me.
Mr. Pridham, do you want to check the answer and report back to us, or after we speak?
yes, I can do, or we can report directly to Katie Duggan herself, but we may be able to get the answers there as well. Which would you prefer, Wendy?
I just think if you could check and let us know.
Okay, yep, will do.
Okay. Do you have any further? No. Now, how much longer have we got till Mr. Exeter is available?
Mr. Exeter could conceivably join us just by phone. He wouldn't be on camera. I would prefer if you want to take a break, maybe we could take the break now, and then Mr. Exeter could be after the break.
Yes, that sounds sensible. So,
yeah.
Should we just make it 10 minutes to keep things moving?
Yep.
Okay, so we'll adjourn now and come back at 3:35.
skulls that kind of peak.
So what is this, sorry? Is this the WSP? Yeah. Welcome back, everybody. Now, Mr. Pridham, do you have an answer for us?
Yes, so this was regarding the sightlines. I received an email this morning as the report that I received for the peer review simply outlined it as an item which needed addressed. However, she has reviewed it again, and I think subject to conditions, this is what it reads anyway. As per the evidence provided, the available sight distances for the vehicle crossing exiting Woolshed Road are 50 to 55 metres to the left, north, and 45 to 50 to the right, south. This breaches Rule 29.5.17a of the QLDC PDP, which requires minimum sight distances of 80 metres for other activities, which is posted with a posted speed limit of 50 kilometres per hour. Accepted solutions could be advanced warning signage on Homestead Bay South approach, advising of private access, and a consent condition could be added to condition 19, stating that the new sight distance resulting from the access widening are to be included as part of the proposed upgrade works for Woolshed Road for council approval. I council to have the opportunity to consider the site distance as part of the proposed upgrade plan to be presented by the applicant. So in short, I believe we can condition our way around that one.
Now, this will be a question from Ms. Baker, but we heard this morning that that table doesn't refer to 40 kilometres an hour, and there's a difference between 50 and 40 kilometres an hour in terms of the required sight lines. So whilst you've applied the table, the real life environment is that the road is 40 kilometres an hour.
Correct. It is 40 kilometre zone. Therefore, an extrapolated sight distance should be used in this instance. It's probably worth getting Katie to comment on that further if we need to go down there that road. However, my understanding is based on what we've provided by Tim Kelly, we're probably okay.
Okay, thank you, Mr. Pridham. I'll now see if we have Mr. Exeter available.
Mr. Exeter is just running to his car in order to be able to connect to us. That was 4 minutes ago, so he is nearly here. I'm not sure how you would like to proceed. I can't make him run any faster, sorry.
Okay, well, I'll get my notes ready and trust that they didn't park too far away. It would just be tidy to hear from all of your experts before we hear from you.
Sure. Otherwise, I can just comment on some of the really fundamental points that you have raised and just clear those out of the way if that's helpful for you in order not to have empty space.
Okay, thank you, Ms. Baker.
Okay, so I think that I've made a number of points and I'm not reiterating my evidence because you have read that. So where I don't make a point changing that, it stands. My first point is the permitted baseline, including 7 temporary activity events. I concur with Ms. Taylor on that, and I think that's actually a really important point that should have been addressed, and obviously is relevant in terms of this proposal. So you could have 7 events, 500 people. Obviously that at this stage wouldn't have any buildings associated with it, but that does put the 31 large events into context, I suppose. It doesn't really change the assessment. In terms of whether trees can be removed from the foreshore as a permitted activity, this is rather a tenuous topic. Now, there has been a recent decision to do with Waterfall Park, which was about planting of trees and whether activities like that could just be undertaken. And the court has advised that they have to be part of a permitted activity because of the structure of the PDP, which now sets out that anything which is not permitted or not listed as an activity is not permitted, such as it was under the ODP, but is now, depending on the particular activity area and zone, either non-compliant or discretionary. So removing trees which are not part of a residential activity or part of a farming activity or part of some other permitted activity is not actually permitted at the moment under the plan. So my view is that they cannot just remove the trees from the foreshore. Nobody can. But that doesn't mean that they couldn't seek consent to do so. And it also doesn't mean that the council is not considering that this is a matter which they have possibly do need to address at some point through a plan change. So my advice to you is currently it's not permitted, no.
Thank you. And is the status discretionary or non-complying?
Well, that would depend exactly where they are on the foreshore, because there's some of it is Jack's Point zone and some of it is rural, so it's varies.
Thank you.
Now I see that there's a phone number appeared, which I'm going to assume is Mr. Exeter, as he's messaged me I'm in. So would you like me to stop there and go to Mr. Exeter?
Yes, thank you.
Okay.
Can you hear me okay?
Yes, we can. Thank you. So, Mr. Exeter, I'm not sure if you've been told that we're asking everybody to give us their comments on what's been heard this morning, and then we may have some questions for you after we hear whether you have any response or comments on what Mr. Trevathan presented this morning.
Okay, no problem at all. Mr. Trevathan has said there is a high level of agreement, this morning Mr. Trevathan spoke to a couple of issues that aren't quite agreed. So first of all, I'll talk about the noise limit condition that would apply to the vacant land to the east of the access way. So Mr. Trevathan's assessment identifies that the noise generated by traffic on the access road will extend over the vacant site to the east of the access way, and part of that site will be exposed to noise levels that are over the permitted standards, and in my view that the noise levels on the affected part of the vacant site will be high enough to create a moderate degree of annoyance in a meaningful proportion of the population, and could potentially cause sleep disturbance depending on the layout of the hypothetical dwelling, its distance from the access way, and whether bedroom windows are open for ventilation. So I guess the question is whether it's necessary in this case to require compliance with a noise limit that prevents these potential effects if a house were built there in the future. In my experience, it is common to consider potential but not fanciful development in the future as part of the noise assessment. For example, Auckland Council's recently released a practice note that specifically deals with assessing noise impacts at potential but not fanciful future developments. And Styles Group have been involved in numerous consent processes and appeals
through the Environment Court, where noise limits for activities in rural zones have been applied both to physically existing receivers and receivers at potential development. So in my experience, this approach is commonly adopted across New Zealand to avoid infringing development rights and amenity of future receivers on a who was there first basis. However, in this case, it's the decision about the potential development of this land and whether the condition needs to recognise these issues. In this case, is ultimately a planning or legal question, and in this case, the owners of the vacant land are also speaking in support of the application today. So, are there any questions on that, or would you like me to move on to the next issue of the 3-day respite period?
I just wanted to be clear. So you were saying that in a similar context, not a rural context, bearing in mind this is within the urban growth area, that conditions of the type proposed, in your experience, have been imposed on dwellings that do not exist and may not ever exist, or conversely, they may.
Yeah, well, that's where, I mean, yes, the conditions are common, but as acoustic experts, we demonstrate that noise is there, and if houses were there in the future, it could potentially be an issue. But whether that is likely and something that is anticipated by the zone or could potentially ever happen, moves sort of out of our expertise and into the planners. So where these sorts of conditions are imposed, it is where it's not fanciful to expect that a dwelling could be established in that part of a site in the future.
Thank you. Commissioner Sinclair, did you have any particular?
Just a point of clarification, Mr. Exeter. Just to make sure I understand it, is it the noise measured at the boundary, not at the house? Is that right?
So the rule as it's written in the plan is at the boundary. But when we're talking about the potential effects, we're really looking at the noise level that would be at the facade of the dwelling. And that's what makes it tricky, of course, because you don't know where a dwelling could be built on that site. It seems like from Mr. Trevathan's assessment, it seems like if a dwelling was within 15 metres of the site boundary, then it could potentially have noise levels that are loud enough to cause disturbance. But again, that would depend on whether there are bedrooms on that side of the dwelling, and of course where the windows are open. But when assessing the noise, we assume that they will be. Does that answer your question?
Yes, and I just you cut out there. Were you saying that is the setback there? Is it 15 metres? And were you saying that if a house was closer than that, there would be an effect on them? But if sorry, I just missed what you said.
Sorry. Yes, that 15-metre setback, that's what I understood from the legal submissions, that Mr. Trevathan's evidence was that if a dwelling was built within 15 metres of the site boundary, then the consent holder may not be able to comply with those noise limits that I've recommended to protect against potential disturbance.
Okay.
So yeah, that setback distance might need to be clarified with Mr. Trevathan.
Okay. And just on the no, that's okay. We're just dealing with this topic. That's okay. That was all.
Great. So if you'd just like to continue with any other general comments on what you've heard. moving on from this condition?
I'm sorry, my phone. I didn't catch the question.
Mr. Exeter, if you'd just like to continue on with any other comments or
yes.
based on what you've heard this morning.
Okay, thank you. There is just one more, and that was that with the 3-day respite period that's been discussed. In my experience, it is typical for consent conditions to include the combination of a limit on the number of events per calendar year and defined periods of respite between events. But as Mr. Trevathan noted this morning, I haven't recommended this as a condition. I've noted it as a typical option for mitigating noise effects from events, and in my experience, it is commonly applied. But in saying that, in this case, it is only the potential effects on hypothetical dwellings on presently vacant land from the vehicles leaving the site late at night after a large function that would really make me consider that further mitigation is required. So I wouldn't consider further mitigation necessary if the effects on the vacant land are not being considered, or there is a condition which prevents acceptable noise levels from being exceeded at future dwellings. Is that clear?
Yeah, that is clear, thank you. Now, is that the last of your points?
It is, yes. I'm happy to answer any questions.
Thank you. Commissioner Sinclair.
I just wanted to understand the issue, your concerns with the, was it the not having with 2 private events or large events in a row, or having a gap between events? I just wonder if you could expand on that issue, please.
Sure. I noted that the way that was the condition, how these events were proposed, with a week beginning on a Saturday and finishing on a Friday, yes. Then the potential for noise events to occur on Friday and Saturday, and having 2 noise events back to back could reduce the make it less tolerable for people who might be affected by the noise, and so typically you would have a respite period between 2 events, and that was something that I felt like should be brought up in case further mitigation was considered appropriate.
And Mr. Exeter, that less tolerable to the noise, is that noise on the road?
Yes, because the noise level predictions for the people on site and music and the other noise sources, they are all compliant with the permitted standards, so or reasonable level of noise. So that I would only really consider that to be necessary if we were considering potential noise effects on the vacant land, because that's where the noise level effects are potentially the highest.
That was all I had, Mr. Exeter. Thank you.
Thank you. Mr. Exeter, just going back to your condition you proposed, if the hypothetical dwelling did eventuate, what would the consent holder do to achieve compliance? What would be required?
There may be a number of options, but whether they are practicable would have to be explored further. So potentially acoustic screening, or the condition of the road, or reducing the number of vehicles. But these are things that would have to be investigated by the by the consent holder. And typically when these sort of conditions are imposed, it is the onus is on the consent holder to investigate how they will reduce the noise levels to comply with a reasonable level of noise at the affected site.
And have you personally been involved as an advisor to a consent holder in such a situation? And what was the outcome?
I can't recall. Well, actually, the one example that does come to mind is gun clubs, where they have where their noise effects are generated onto land that doesn't belong to them, and they've used land around them as a buffer, and then as that land has been developed, people get closer and closer, and in some cases that we have been involved with, the gun club has actually had to reduce its activities because there was no other way to mitigate the noise. So yeah, in some cases there aren't practicable physical mitigation measures that can be put in place, and it comes down to management measures or reducing the intensity of the activity so that the noise emissions are lower.
Thank you. Now, one of the other questions we talked about after lunch with Ms. Taylor was what's the difference between the effects of an event of 100 people or 98 people, and is the condition proposed appropriate given your opinion that there could be effects that might make people annoyed and unable to sleep, which differs from Mr. Trebacken's opinion that was unlikely.
Mm-hmm.
So
yeah,
had you considered whether there was a need for a condition to deal with smaller events that are still just under a large event, given what you've told us just now?
Yeah, it's a good question, and I mean, essentially the difference between 98 and 100 people is not going to be noticeable, I would imagine. But I suppose that, I mean, it's really drawing a line in the sand and saying that, you know, with events less than 100 people, then the traffic movements would be that much lower, and that the noise effects would be lower than for larger events. But when if you talk about the difference between 99 people and 100 people attending, then there wouldn't be any difference in terms of the noise effects.
So your recommendation for the respite gap, was that just for the large events, and would it not be equally applicable based on what you're telling us that could apply to smaller events? I'm just trying to understand why there was a focus on these larger events requiring a gap and not things that are just a shade smaller but still fairly large. Yeah. And what your reasoning was for that.
So I guess with the respite periods, again, we're really only talking about we would really only think that would be necessary if we were considering effects on the hypothetical dwellings. So in terms of the existing dwellings, the noise levels are 45 or less at the dwellings at the moment. So that wouldn't typically wake anyone up, and it wouldn't be expected to cause moderate annoyance for most people. So yeah, I wouldn't necessarily recommend that 3-day respite period is imposed if we're not considering the effects on the potential development on the vacant land. So, but I think yeah, as I said, like the difference between 99 and 100 people is not going to be different in terms of noise effects, but I guess it's just a line in the sand for quantifying what is a large event that may involve a large number of traffic movements, and what is going to be have lesser effects because there are fewer cars.
Thank you, Mr. Exeter. I don't have any other questions in this.
No, neither do I. Thank you.
Okay,
Thank you very
my pleasure.
much.
Thank you.
Now, Ms. Baker, you can resume. We've got your 2.
Thank you, Commission. Yes, you have my 2 points, so I will just simply carry on down my list. I might start at the end, though, and just comment on the acoustics as it's fresh in your mind right now. So my planning wash over the top of Mr. Exeter's advice is that you have in a situation where there may be hypothetical dwellings on this site in the future. They will be fairly limited in number. They are likely to be set back further than 15 metres. I think that I agree with Mr. Trevathan that it's very difficult to monitor a condition like this, and you've obviously heard from Mr. Exeter what difficulties there may be in trying to enforce it in terms of what would be expected. I don't consider these conditions are essential, given that the Jardines are in support of this proposal and it is their land. So my view would be that we can dispense with these conditions on noise effects on hypothetical dwellings, which may or may not eventuate, given the small, very small level of effect.
Thank you, that's helpful. One less matter in dispute. Thank you.
Right, in terms of, you've been discussing whether there are consents have been granted in this district with deferred connection to reticulated, in particular, wastewater systems. And I am not entirely sure whether you've received a clear answer on that, but my experience is that that has occurred, but I am not aware of anywhere trucking out is the option. I'm only aware of situations where disposal to ground or septic tanks has been approved, and an encumbrance in the form of either a consent notice or a covenant has been placed on the property requiring that connection is undertaken at the time that it does become available. I think that is a different situation to this, where there is no disposal to ground option, so we are left with trucking out. So I think that's a slightly different situation, and I don't know any consents granted where trucking out has been considered an acceptable temporary solution. In terms of the 50% rule, I agree with, I think it's Mr. Espy who has raised that it only applies to freehold land, and Crown land is not freehold land. I had not realised this until he pointed that out, so thank you for that learning curve. There is no corresponding rule in the ODP. So whilst this rule is under appeal, it doesn't, there is no rule in the ODP which remains triggerable. So that's not of relevance.
Sorry, Ms. Baker, where does that leave us with the issue?
It leaves us that there is no expectation set by that rule in the plan that the Crown land, which is immediately to the east of the subject site, will have 50% Indigenous vegetation on it. Given it's a reserve, there may be other expectations, but that particular expectation is not set. And it also leaves us with no ODP rule to trigger.
Thank you.
In terms of Mr. Denny's advice, which I do rely on, I think his advice to you is that what is being proposed is not going to result in mitigating the effects in his view. And I think that the important point here to understand, particularly in terms of vegetation on the foreshore, which is being relied upon, is that if this is consented, we potentially will have very little visual softening and visual, not so much screening, but the veg is likely to look like a quite unvegetated site. Now, I understand from the applicant's point of view that this is simply a progression of the urbanisation of that area, which is anticipated, and it progresses further and further west, and that this will just be another step in that. My view is that this is not what the district plan is anticipating here. The district plan is anticipating that this is a progression, very much a progression from a urbanized area through to a much less heavily built form through to the ONL. So I would consider that the landscape plan that they have provided doesn't achieve sufficient to mitigate this proposal if the foreshore trees were to be removed, which is out of the applicant's control. So it's my advice to you that you have to consider that they could be removed without the applicant having any control over that, regardless of whether it's permitted. And if that happens, we will end up with the built form being very prominent on the foreshore. In terms of the 10-year lapse date, I have no concerns with the 10-year lapse date. 10 years is quite a common lapse date to be granted in this district where proposals are large, and it aligns well with the review period for the district plan, which is supposed to be 10 years. So it's unlikely that we'll have another change in that period. I disagree with Mr. Leckie's view that once stage 1 is given effect to, the consent is given effect to, and therefore stage 2 can progress at any time in the future. This is not my understanding of how staging works. My understanding is that each stage pretty much stands on its own, and unless stage 2 is commenced prior to the lapse date, stage 2 will not be able to be given effect to unless you specifically were to state so in your decision that you wished it to be able to be progressed later. This is probably a matter, more of a legal matter and slightly outside my area of expertise. So if you wished for the council to provide a legal opinion on this, we could do so.
We will discuss that and
sure. Yep, sure. In terms of the earthworks consent and ORC, the only comment I wanted to make on that was that since ORC now deals with earthworks, it has been fairly common practice for QLDC to collaborate with ORC to make sure that we have similar earthworks conditions, so the applicant isn't trying to comply with two either contradictory or over onerously slightly different sets of earthworks conditions. Obviously, in this case, we have not been able to do that. So if you were minded to grant consent, I would suggest that as part of the conferencing with Ms. Taylor on rules and objects and policies, you also seek that we conference on conditions, and I will liaise with ORC to ensure we are aligned.
Thank you. I think that is a helpful suggestion. So if we could add that to your homework list, please.
Yeah. So I agree with Ms. Taylor that the spatial plan and the iwi plans are other matters under section 104. I accept Mr. Espy's reference to my paragraph 8.12, where I have said that I have interpreted Mr. Denny's moderate to high as significant, and I would like to amend that to more than minor.
Would you like to be invited to qualify that further as to how much more than minor?
I would not, thank you.
Would you say it was moderate or confined? Would you give any more colour to that other than just more than minor?
Well, that was probably the reason why I put significant, because I feel that more than minor is a rather loose term. But I stand corrected by the NZILA scale. So, I mean, it's substantially more than minor. Maybe I can say that.
Thank you.
I've commented on that one. The Archaeological Authority, I agree that should be an advice note and not a condition. And I agree that traffic management plans should be reviewed, and the council generally would recommend a section 128 condition in terms of activities which are ongoing, not in terms of built form. So that aligns with Commissioner Sinclair's comments. So that is agreed. That brings me to wastewater, which is obviously, well, in my view anyway, the big topic here. I was very pleased to hear that the university is not intending to construct buildings and leave them standing there vacant, because that was fairly problematic. As a general concept, that resolves my concern around that matter. However, I do, having talked to Mr. Pridham and heard his evidence and relying on that, I do think that that condition needs to be quite well crafted to ensure that there is actually wastewater available. So the condition as it is currently drafted just says construction has commenced. I'm just trying to find it now. And as Mr. Pridham said, there are a number of stages to construction of the wastewater, the Southern Corridor wastewater pipe. So there is the main trunk, which will start at, presumably start, I don't know how the construction would work, but would start at one end. Presumably the sewage ponds in Frankton would come all the way along State Highway, go into Homestead Bay, and judging by the plan proffered by the applicant, would end at the marina. Now, construction starting at the Frankton sewage ponds on this, that gives no certainty as to when anybody will be able to, or when the applicant will be able to connect into the trunk main. So there needs to be a higher degree of certainty on that. I'm not sure whether the applicant intended as Mr. Pridham suggested, that the trunk main has to be commissioned and basically operational before they start construction. I'm not quite sure what they intended, but that would be my view. It needs to be in a position where they can essentially connect into the trunk main before construction on the stage 2 dwelling should commence, in my view. And this is simply to avoid exactly the same situation, that if the trunk main gets stalled, doesn't get completed, has any other problems in becoming commissioned, then that once again leaves us with buildings which are just sitting there vacant. And my understanding is the university doesn't want that either, but the council also, in my view, should safeguard against that, and particularly against concerns that they will be pressured very heavily into allowing an alternative solution if this does happen. So it's something that needs to be avoided, in my view. And it can be by a condition. So assuming that the condition can be crafted in that way, that alleviates my concerns around the stormwater issue, the wastewater issue. And I'm happy with that. And I'm sorry, I should just reiterate, in that context, the Three Waters entity, just bringing another layer of confusion into this. My understanding is that within the next few years, Three Waters as an entity will also take over wastewater, and it will be out of the council's control as well, what happens. My final comment is on the potential plan administration, confidence in plan integrity effects of stage 1 and trucking off site. Now, I do think this has the potential to set an undesirable precedent. But on balance, my view is that the positive effects of this proposal in terms of probably the matters that Mr. Jardine raised and in his submission, and the intention of the Jardines and bringing the university to the district and bringing this fairly unique proposal to the district can be considered by yourselves under other matters. And I would consider that in this case, those positive effects can be weighed against the potential confidence in plan administration that may be undermined by allowing waste to be trucked out in this instance. So my advice would be that stage 1 can go ahead prior to wastewater connection being available, without it undermining plan integrity significantly with those provisos. And I think that brings me to the end of my notes.
Thank you. That was very comprehensive. I think you've touched on many of the issues raised. Commissioner Sinclair, do you have anything left on your... I could say some orange highlighting.
I've been furiously crossing out my list, so thank you, Ms. Baker, for your response there. There's a couple of tiny little things I need to check, and it's to do with the front page of the Section 42A report. And it's to do with public notification date and closing date for submissions. We've got one after the other, or one before the other, and I just wanted to make sure what was so I just wanted to make sure what was the notification date. We have at the moment got submissions closing before it was notified, and I just wanted to make sure we've got that right in our decision.
It should be, no, it was notified. I have that it was notified on the 9th of December. So that February should be December 2021. I apologize. And then submissions closed on the 27th of January 2022. So that is correct. So my apologies.
Thank you for that. Just wanted to ask you a question on the ODP, and Ms. Taylor has considered it still relevant, but you haven't considered the ODP And I just wanted your response. Have you rethought about that, or you still stand by that the ODP does no longer need to be considered?
Okay, I think to say it's completely irrelevant is legally incorrect. So I wouldn't say it's completely irrelevant, but to say it needs to be given any significant weight at all is, in my view, now obsolete. We are well past the stage where the ODP has significant weight and should be considered in any significant, to any significant extent. So you know, you could undertake a whole assessment of it and then negate it by saying, well, but it shouldn't be given any weight. That to me is somewhat trite and rather a moot point.
Okay. Ms. Taylor has included the National Policy Statement for Freshwater Management 2020. You haven't considered it. Do you have a response to that? And is it relevant for us?
It's relevant insofar as it applies. Just need to refresh my memory as to what Ms. Taylor said about it. Do you know which paragraph she addressed that?
It's in paragraph
120.
120.
120.
It was mainly about impacts on Lake Wakatipu.
Yeah, I mean, she has addressed it, and I would agree. I concur with her. There is not going to be any effect on groundwater or freshwater, and the proposal complies with the MPS.
Great, thank you. You would have heard our questioning along the lines of, or you may have said that traffic management plan. Did you address that?
Yes.
And you agree with those type slopes? That's okay.
Yeah.
I hadn't crossed that off. My last question was just some information on the structure plan has, I think it must be by the playground in Jack's Point. It has an education use. Just wondered if you had any knowledge about that. Was that a high school or is that a proposed primary school?
I don't know, sorry.
Okay. No, that's okay.
I can potentially help there, Commissioner, if that assists.
Thank you, Mr. Lucy.
Sort of help. There's currently a 293 process going through the Environment Court for some changes to the Jacks Point structure plan, and they're not relevant to this site. But as part of that, one of the proposed changes is the removal of that education area from the structure plan.
Okay. Yeah. And that was section 293.
293, yeah, through the PDP process.
Okay, thank you. And that was all I had, Ms. Baker. Thank you.
Thank you.
Right. I had a question on your section 40 co-report at your paragraph 8.6, talking about the cultural values from Karuna. You commented that some rewordings needed to make it monitorable and enforceable, and I was wondering if you could assist with being more specific about what your concerns are there.
Well, those were the conditions that were proposed in the letter from Okahu, and yeah, yes, I just need to pull it up. Oh, I think I actually copied them here. So this is a bit similar to the issues that Mr. Denny raised with the landscape conditions. A condition which says a planting palette which encourages bird and insect life. Similarly, species of plants should be selected based on their whakapapa and contribution to ecosystems of the area. These are conditions which are very, very difficult to monitor and enforce, and the monitoring and enforcement team at council will struggle to understand what we actually expected here if this condition is imposed in this format. So this is simply problematic with things like that, and I'm sure that you would understand that they just simply wouldn't know what bird life, what insect life is being encouraged. I think the plants being selected on their whakapapa, I think that is clear. But what contribution to the ecosystem are we expecting here? So those matters need to be much clearer in order to enable them to actually be implemented. Otherwise, they will simply get lost in translation between the consent and the implementation.
We did have the comment from Mr. SB, I think it was, that the species selection would attract bird and insect life, so we can, we do have some comment on that from him. Okay.
Yeah, so I guess that's exactly it. So that's it. That's solved that problem, and we've already got there. So we don't need this condition because there is nothing more for them to do then, unless we put some kind of quantity in it or something else. So they're just simply, I mean, I guess this is a question of, you know, if you're minded to grant this consent and you'd like Ms. Taylor and I to agree on conditions, then we can put some words around this which maybe allow for a little bit more certainty around what is actually anticipated to result from this. But as a general concept, these conditions, you know, these ideas, I have no concerns with at all.
Thank you. Now, I'll just check my final list. One of the things we heard from Mr. Leakey this morning was about this idea of the hierarchy of the moving from the east to the west in terms of the level of urban development and the intensity that with the ONL being undeveloped and then the development gradually becoming more urban as you move across to the marina and so forth. And sorry, I had a question in this somewhere. It's the end of the day. Oh, that's right. From a planning context, is there any guidance in the objectives or policies or introduction to the chapter that give any more colour or description of that?
Of that, well, I don't remember Mr. Leckie using the word hierarchy. I think the plan doesn't anticipate a hierarchy because it, to some extent, anticipates a few residential units in this location on very large sites, potentially, or else a very few clustered, but with a large open space around it. And moving over then to the marina and the dense residential development as we move east. But I'm not sure, I'm in my view, this is not achieving that. This is achieving something completely different. It's achieving what will be perceived, at least in views from the lake, as a fairly significant development. The suggestion by Mr. Leckie that all 10 houses would be located right here on the lakefront is unlikely in my view, or at least it would hit the same landscape problems that this proposal is hitting.
So that neatly leads on to my final question, that is your recommendation from what you've heard today that the application should still be refused?
I knew you were going to ask me that. My recommendation is probably that with appropriate conditions in terms of wastewater and with a clearer condition in terms of landscaping, it can be granted. And particularly when I say landscaping, I mean the condition about the removal of landscaping from the foreshore and the replacement that would be put in place. I would like that condition to spell out a lot more detail. But with those two conditions, my recommendation to you is it can be granted.
Thank you very much for your assistance and clarification, Ms. Baker. It was helpful to have your sizable list from the hearing. I think where that leaves us now is that we've heard from everybody and now need to leave you, Ms. Baker and Ms. Taylor, to work through that summary for us to give clarity on the consent triggers and the relevant objectives and policies for our consideration. And then lastly, the conditions, given Ms. Baker's comments. Now, I do have a question about how to work through the landscape plan comments from Mr. Denny. I think it might be rather unfair to expect him to conference with Mr. Espy on that, and perhaps whether the applicant would like to propose that that plan could be revisited, and or whether you wish to leave it as it is if it's
not conditions. We can put up new conditions.
Oh, sorry. We're off mute now. We were sorry about the background. We were just talking about the different options around that. But from the applicant's perspective, there are some things that could be done to the landscape plan. So we'd welcome the opportunity to do that. There's probably some more fundamental points of disagreement between Mr. Denny, and Mr. Espy. So I'd agree that potentially conferencing is not the most productive or constructive way to work through that. But we've heard Mr. Denny's concerns, so perhaps we put together a revised landscape plan. There's some interaction there with the conditions as well from Ms. Taylor and Ms. Baker to look at. As well, particularly around the condition on what happens if the landscaping within the Lynn's land is removed. So there's a planning lens to that question. So I provided quite a long answer, and I'm just trying to loop that back to the question. But essentially, if we could have a step in the closings process for the revised landscape plan to be provided, I think that would be helpful.
So I think what I would suggest is that perhaps this comes first before the conditions, because you've just highlighted the connection between the conditions and the plan. So I think I would like to request if Mr. Espy and the applicant wish to work through that landscape plan and what's been discussed today, and provide that at a date that is convenient and fits with your workloads. And then following on from that, Mr. Denny could perhaps provide a brief response, and then we could receive from the planners their recommended conditions as well as those other two matters. How does that sound?
Yes, no, that works. And I think just to add my perspective, I think that it'll be helpful to get Mr. Denny's response, but I think that doesn't necessarily need to change or influence necessarily what the planners get to. I think the planners exercise is potentially a partially discrete exercise anyway, but that's fine. I'll just look to Mr. Espy, maybe 2 weeks.
Yeah.
We're just proposing 2 weeks for us to do the first step, which is updating the landscape plan.
So we say the 1st of July?
Yeah. I'm just very conscious that every RMA practitioner in this town is pretty slammed at the moment across the board, I think. It's probably a point of agreement. So I think let's not overpromise and underdeliver on timeframes. and then I'm relaxed. Perhaps I can pass to Ms. Baker or Mr. Denny, whether it's a 1 week or 2 weeks for Mr. Denny to respond. Ms. Baker and Ms. Sinclair, Ms. Taylor, sorry, could be progressing their work on the planning aspects at the same time, potentially, as Mr. Denny's preparing his response.
Yes, I think Ms. Taylor and I can certainly progress to a very significant level and just be waiting on the landscape issues. Potentially, I just need Mr. Denny to advise on his workload, really.
Mr. Denny. We've got the black screen of death logged out for the day.
I can respond within a week. We're receiving a plan. That should be okay.
Thank you. So if we leave this relatively fluid, given the parties all have high workloads and you can work together, and then Mr. Lecky, how long after this do you think you need for your reply?
So we can get aspects of our reply underway already. So just perhaps a week following the filing of the planning documents, if I could have another week, that would be appreciated to incorporate that. And then so a week following the filing of the planning JWS, we could file our closing right of reply, including condition.
Commissioners, are you intending the planning conferencing documents are filed with the closing submissions by Mr. Lecky or separately?
I was intending prior, in case there were any questions, which I doubt there will be, but just in case.
Yeah, that's fine from our perspective.
Yes.
Okay, so I think, I'm not sure what Ms. Taylor thinks, but by the 15th of July, we could definitely have those filed.
I can work to that.
Yep.
Yeah. And then a week following for the legal.
Yeah, 22nd of July. Perhaps if you just communicate through Ms. Anderson if there's any difficulties for anyone in this, but let's set those dates. So I have Mr. SB, then 1 week for Mr. Denny, and then planning by 15th of July and right of reply by 22nd of July.
Just speaking for Miss Anderson here, things that are filed with the council, if they can be filed by noon on those days, so she has time to actually get them sent out, that's very helpful.
Yes, I wouldn't like Ms. Anderson to have to work till 8 o'clock at night. People push it to the limit of a working day. That's helpful. So let's say 12 p.m. Thank you, Ms. Baker. Well, I would like to thank everybody that has presented to us today for assisting refining the issues and your willingness to assist us, and very helpful, if I may say, for myself and Commissioner Sinclair. So we'll look forward to receiving these documents in due course, and thank you for your clarity and assistance, everybody, today.
Yes, thank you very much.
Thank you.
So we'll now adjourn.